He was going to be our third roommate.
He helped out with the rent. Then he helped himself to your girlfriend.
Correct.
Hey, try not to hold each other's hands. Let's do the coochie-coochie someplace else.
Jalil is suing his former roommates, Katie Calderon and Amante Nepomuceno, for rent and the cost of 2 cats.
Court come to order. All rise.
Have a seat, everyone.
Kevin approaches Judge Judy.
Case 2170, Jalil versus Calderon Nepomuceno.
Thank you. You're welcome. Oh, my goodness.
Judy turns to Katie.
Calderon,
Hello.
what's your first name?
Amante.
Amante.
Yeah.
Good. It's much easier than your last name for me to pronounce. Mr. Jalil, this roughly is what the case is about. You and Miss Calderon were in a relationship for a period of time. You decided to take an apartment. You were both on the lease. So far, correct?
Correct.
Your arrangement with Miss Calderon, which seems to be consistent in both your complaint and your answer, is that you had a much better paying job. She was going to provide the food and some other stuff for the house, and you were going to be covering the rent when you lived together, which you did.
Correct.
There came a time when Armante, who was a friend of yours, came to live with you. According to you, he was going to help out with the rent.
Correct.
He came, he lived with you, he helped out with the rent for maybe a period of time, and then he helped himself to your girlfriend.
Correct.
Now they're a couple. When you were no longer a couple with Miss Calderon, she stayed in the apartment for a period of time, but then they both left.
Correct.
And you're suing both of them for rent and for the return of 2 cats that they took when they left. You claim the cats are yours.
That's correct.
That's what the case is about. And some cat expenses in the event that I let them keep the cat. Cats, 2 cats. So when did you and Miss Calderon sign a lease together?
We signed the lease together at the end of July with the landlord present.
July of 2022?
July of 2021. Correct.
And it was for a year?
Correct.
And you had a job working for whom, sir?
I worked for a company called Steris.
What do they do?
They provide medical equipment to hospitals all over the world.
How long have you been working for them?
I'm going to have 8 years under my belt this year.
And when you moved into the apartment in July of 2021, what kind of work was Miss Calderon doing?
At the time, she was working at I want to say an animal hotel.
It was a pet daycare boarding facility.
Okay. Were you an hourly employee?
I was an hourly employee.
And I am correct that when you moved in July, your arrangement was that you were going to pay the rent.
That was...
The arrangement.
Correct.
When did Armante come to live with you?
About August to...
That's
Right.
correct.
Shh.
He...
Just...
Judy glares at Katie.
Amante was going to be our third roommate.
You mean 1, 2, 3?
Correct.
Well, you're not roommates, really. You and the defendant, Miss Calderon, were not roommates. You shared a room.
We shared a room and
Armante was going to live where?
in another room.
And what was your arrangement with Armante with regard to paying rent?
We would split the rent 3 ways.
Is that correct?
Yes.
And how much was your share of the rent?
I would say approximately 927.
How long did you live there?
I was there when they signed the lease. I watched it all happen when they signed the lease. I came in, they signed
Okay.
everything.
Well, you didn't sign the lease,
I did not.
but you were there from the beginning?
Yes.
And it was your agreement with the plaintiff that you would pay 1/3 of the rent?
Yes.
Great.
We asked the landlord
Okay,
to.
so, hey, try not to hold each other's hands. Let's do the coochie-coochie someplace else. So you agreed with the plaintiff that despite the fact that you were not on the lease, you were going to assume the responsibility of 1/3 of the rent, $927.
Yes.
So you moved in July, August, September, October, November, December, January, February, March. You left in April?
Yeah.
So you were there for 9 months.
Yes.
Did you pay rent for the 9 months?
Yes, ma'am.
Is that correct?
He paid rent for about the 7.5 months.
Okay. And then you left.
Yes.
Why did you leave?
I decided to leave because he decided to go to another place he was offered. So
What do you
I
mean he
could-
decided to go to another place
He
that was...
got a place from his grandparents in another city. So I couldn't hold down the rent with her. So I decided to leave to save money and go back to my parents' house.
Now, Mr. Jalil, you see, you don't make up a story like that, like he just told me. A lot of that has the ring of truth to it. Where are you living now?
My grandparents' house in an in-law unit
So when did you tell them that you were going to a different place?
in March.
When did you leave?
I left in July.
Did you let him know that you were staying until the end of the lease?
I
What?
I
What?
I discussed with them that I would be leaving, but I would stick around to help them find either a different location or even suggesting that we all went back to our respected families just to, call it.
Mr. Jalil, this isn't working for you. I have to tell you something, sir. This case is not working for you at all. And it's only because Mr. Amante is very direct with me that you're suing them for $10,000. Where does that come from in your mind? Your agreement with her was you were going to pay the rent. You were never out of pocket. Your agreement was you were going to pay the rent. He paid his rent when he was there. He paid his 1/3. You then told them you were leaving. That's a whole different story than what you wrote in your complaint, Mr. Giulio. Do you understand?
Correct.
It's a whole different story. So, at best, Armante would owe you for 3 months' rent if they just left. But you told them that you were leaving. Now, when did you find out that they were a couple?
I found out at the end of April.
Were you all living together?
Yes.
So you just had 2 months left to the lease. So he was paying you, he paid you in March, you had May, June, you signed the lease in July, so it was over at the end of June, June 30th.
It would have been over at the end of July, Your Honor.
Well, she doesn't owe you any money for rent. At most, he owes you 2 months' rent. Tell me why you left.
My job doesn't pay that well, so I decided to go back to my parents' house.
When you took this apartment, this expensive apartment that was almost $3,000 a month rent, had you had a discussion with Armante about moving in with you before?
Yes.
Okay. Mr. Jalil, I'm reading your complaint because something wasn't registering right with me. You say you moved into the apartment together in August of 2021. Then you go through a whole bunch of stuff about a cat and then another adopted cat. You said in October we adopted a second cat. Around this same time, a third roommate moved in to shoulder some of the rent. Well, that's not true. He moved in right at the beginning.
And that was
That was what?
that was
A mistake.
that was a mistake.
Okay. But Armante acknowledges that he agreed right at the beginning. He volunteered the fact that he was there at the lease signing because it was agreed at the lease signing that he was going to pay a third of the rent. So, sir, you owe him rent as long as you show me that you've paid the rent. You moved out in July,
Yes.
and you paid your rent through July, or were you evicted?
No, I paid my rent in July.
Through July?
Yes.
Okay. 1854. Armante, you owe him $1,854. That's for 2 months' rent. Got it?
Okay.
I'm not subtracting anything because you stole his girlfriend.
That's fair.
Caption. Coming up.
What were you requesting when you filed your small claims case?
Either the return of both cats or $5,000.
That's not happening for you, Mr. Jalil.
And later today,
There were restrictions put on the space.
No.
You have to pay attention,
Okay.
sir, because what I'm suggesting is really in your favor.
Oh, okay. Let me. Okay.
A courthouse. The Judy Justice logo appears. In the courtroom, Kamar, Katie, and Amante.
Kamar Jalil claims his former roommates, Katie Calderon and Amante Nepomuceno, are wrongfully keeping his cats and owe him rent money.
Now let's deal with the issue with the cats. She doesn't owe you any rent. That was not your agreement with her. You moved out in July, August, September, October, November, December. 5 months ago, she's had both cats, right?
Correct.
She says they're her cats. When did you first file a small claims case?
September of 2022.
What were you requesting when you filed your small claims case? Be careful.
I was requesting either the return of both cats or $5,000, which was the accumulated expense of not just the cats, but also the expenses of her dogs as well. So any animal expenses for
Okay.
the time.
That's not happening for you, Mr. Jalil. When the cats were either registered or went to the vet, whose name is on the sheet as owner?
I believe it was Miss Calderon.
Is that correct?
That's correct.
And she owns the cats, and she's had them for the last 5 months. I suggest that you go and adopt 2 more if you want some more cats. Do you understand?
Yes.
You were living together as a couple. However, your friend Amante has to pay you for the couple of months' rent that he didn't, because he says, not you, he volunteered that was your agreement from the very beginning. So he owes you $1,854. We're finished. Thank you very much.
This court is adjourned.
I think he's just kind of butthurt that I moved on.
At least now I can put everything behind me and say that I did try.
I didn't think it would escalate this far.
All you can do in a situation like this is just you learn from it and you move on.
The heart wants what the heart wants.
This is what it is. It's life.
Judy.
I find fascinating, Sarah, that people will write and or be assisted in writing a complaint and an answer, but they read it over. This man is an intelligent man. He has a serious job for 8 years. First of all, he was suing for $10,000. Come up with that money. $5,000 for the cat's expenses, ridiculous. But his complaint had really nothing to, even the timeline.
As your clerk, I know that is a pet peeve of yours when
I don't understand
they
it.
don't
You know,
match up.
if you're going to tell a lie,
At least tell a consistent lie.
right.
I think the right thing happened. I think the defendant friend admitted himself that he owed the
Well-
rent, and that was great, even though he probably should have just kept his mouth
Zipped it
shut. But,
and not said, I was there when the lease was signed. This was always our agreement.
Yeah.
I was going to be the
but
third
he was
roommate.
honest, which we always appreciate. And so I think the right
You
thing
know, so
happened. I think he needs to, like you say, put a period, move on.
move on. Anyway, all happy. And they look happy. They couldn't keep their hands
Oh,
off each other.
Case number 2172, Foster Gardner versus Menzel. All parties, please come forward.
Jamar Foster and Sean Garner are suing record producer Livin Manziel for event costs after Livin canceled their Halloween party.
Who's Mr. Garner? Mr. Foster.
Right here.
Are you going to be speaking? You're standing in the speaking spot.
Yes, ma'am.
Okay, great. According to what I read, the defendant rents a music studio. Is that correct?
I rent a facility in which I own a music studio.
You rent in someone else's building.
Yes.
And you're recording people. During the course of your business, you decided to enter into an agreement with the defendant to use that recording studio, which she rents from that space, which she rents from a landlord.
May I correct you, please, Your Honor?
Yes.
She actually is a facility that has multiple units in it. She runs a studio, and then there's other event space inside of that same facility.
Okay, give me an idea of how large the space is.
I believe we were quoted something like 5,800 square feet.
And so you have a music studio, and around it is other open space.
Yes,
You decided to go into some sort of a business with her. You wanted to run events,
yes, ma'am.
social events, nothing to do with the music studio.
Absolutely not.
Is that correct?
Yes,
And according to you, you gave her $6,000,
yes, ma'am.
sort of front money, to start using that space.
Yes, ma'am.
Subsequent to giving her the money, according to you, there were restrictions put on the space, on the number of people you could have, the kind of parties you could have, et cetera.
No, absolutely. I apologize.
Well, you have to pay attention,
Okay.
sir, because what I'm suggesting is really in your favor.
Oh, okay, let me, okay,
So, is really in your favor, so you have to think.
okay.
Subsequent to giving her, that means after giving her the money, restrictions were put on the kinds of events and the number of people you could have in the space. Is that true or not true?
That is absolutely true.
No, that's not.
I'll get to you in a second.
Okay.
And you want your $6,000 back.
Yes, ma'am. In
That's what
addition
it's
to-
about. The defendant does not deny that you gave her $6,000. And then I'm going to hear what her defense is. So I want you to tell me when, for the first time, did you have a discussion with the defendant about going into this business venture where you would front the money and whatever events you would have there, you would reap the benefit, the financial benefit from that. When did you have that discussion with her?
Okay, so we met living at the end of August of 2022. We actually signed the agreement pretty fast. We signed the contract agreement on September 1st.
May I see the agreement?
Yes, ma'am.
There was no agreement signed, so I don't know how it could be signed.
She keeps arguing that.
Just a second. Could you be quiet?
Yes, ma'am.
Jamar hands the document to Kevin, who brings it to Judy. She reviews it.
So in your hands,
Shh. What's
that's the studio that she runs?
Sarah? You have to sort of explain it because I don't see signatures. You know, I'm used to looking at contracts where people sign things, but I know you can sign things by DocuSign now. Your signature isn't on here.
Yes, ma'am.
And
That looks like a signature from a DocuSign or some sort of online.
okay, is that you?
This was a proposal that I did. I do not even own it yet as a DBA.
Just a second. It's getting better. Don't say anything. This is your proposal. Now I'm going to read it.
Okay.
And your masterpiece management.
Yes, ma'am.
Okay, well, so this is sort of easy. You prepared this proposal. Speak.
Yes, after.
Just a second.
Okay.
You
Yes, ma'am.
prepared this proposal.
Yes, ma'am.
And as a result of this proposal, you received and deposited $6,000.
Yes.
Yes, well, then you have a binding contract, okay? So that's what I'm telling you. You have a binding contract. And there is nothing in this contract that limits the kinds of events or the number of people or anything else with regard to this space. All it says is business activities, event planning, and event rentals, nothing else. And this is your proposal, so the terms of it are construed if there's any material question, since you prepared the agreement, which became a contract once you accepted their $6,000. I view the terms of the agreement most harshly against you because you prepared the document. And it says, this agreement cannot be amended without the written consent of all parties.
Yes.
Yes, so sign the agreement, you got the money, and then at some point, according to them and according to you, you made certain limitations on the kinds of events, the numbers of people, et cetera.
That is.
Now that happened according to you because you do not own that space, you rent that space, and there was a problem with the first party that they threw.
Correct.
Come on, we're not talking about Gone with the Wind here. We're not talking about a 6-volume masterpiece. We're talking about a yes or a no.
Caption, coming up.
Based upon this proposal, they gave you $6,000, which you deposited into your bank account. That means a contract was created. That's the agreement. I'm telling you, that's the law.
A courthouse. The Judy Justice logo appears. In the courtroom, Jamar, Sean, and Livin.
Jamar Foster and Sean Garner claim record producer Livin Manziel broke their agreement by canceling their event. Livin is countersuing for the costs of a recording session.
Okay, there was a party that got out of hand.
Yes, ma'am.
Okay, and after that party that got out of hand, too many people or whatever it was, your landlord complained.
Yes.
Okay, and it was after that that you told your 2 partners that the...
We are not partners.
Yeah, according to this, you are.
We didn't finalize the agreement.
This is a finalized agreement, madam. I just said to you, I want you to pay attention. This is your proposal. Based upon this proposal, they gave you $6,000, which you deposited into your bank account. That means a contract was created. That's the agreement. I'm telling you, that's the law.
Okay.
You prepared the proposal, you signed it, they said, okay, and they fulfilled their part of the agreement by giving you $6,000, which you accepted. Got it? Got it? And you can't, according to the agreement that you prepared, modify this agreement any other way than a written contract signed by both parties. You can't change the rules. Did you know that this was rented space?
We didn't have all of the details about the place.
Well, see, next time you should know what you're dealing with, whether she's the owner or whether she's not the owner, whether she's a renter, whether she has the ability to rent out to sublease for events. I mean, all of these things, before you give somebody $6,000, you should know that. Okay. And you had one event at the space?
No, we actually didn't get an opportunity to throw any events at the space at all. The event that you were speaking of, she had partnered with another group of promoters and individuals to throw that party. So you
didn't have anything to do with that? What was it, a Halloween party or something? It was a Halloween party, but that wasn't with you?
No, that wasn't.
Is that correct?
He was a part of the event.
Is that correct that
No.
it was with other people?
Yes, it was correct. It was with other people. They were just associated with the event. They worked at the event. And
I don't
so-
care whether they worked at the event. You received money from other people for an event.
Yes, ma'am.
Well,
Yes,
let's be clear. And after that event, you imposed additional restrictions on the use of the space.
No, Your
Just
Honor.
hold on a second.
They knew about the event.
Hold on.
They
You can't tell me what they knew. This is your contract.
They called a fire marshal.
My landlord contacted me that the neighbors were complaining. People were parking on their lawns 90 minutes into the party, but it was not their party. Somebody else paid you for it. The next party they wanted to throw involved minors, and I told them absolutely not.
Yes, ma'am.
I just made it clear what types of events would be approved. Well, you can't do that. I'm just telling you, you can't do that.
Ma'am, I'm not allowed to throw events that have out drugs for children.
You have to understand something. You can do whatever you want as long as you put it in a contract. You prepared the contract. This contract is silent as to any restrictions on the space for events. So you have to give them their $6,000 back because they didn't have an event. They got nothing of value for their $6,000.
Correction. They were managing an artist whenever I met them that they were responsible for paying. So I'm countersuing them for $1,050.
Just a second.
Okay.
$6,000 they get back.
Okay.
Easy? That's a because Now, you have a counterclaim, and your counterclaim is for $1,000 because you say they owe you that for a rental that they did for an artist that they manage.
I provided my services as a recording artist and a music producer for their artists. I provided them with 2 exclusive beats.
Well, show me the contract with them.
I have.
Just show me the contract with them.
There was no contract.
Judgment for the plaintiff in the amount of $6,000. Counterclaim dismissed. We're done. Thank you very
Court
much.
is adjourned.
I was just trying to have a proposal, not a finalized agreement.
Well, I appreciate us getting some type of justice out of the situation.
They came in wanting to do multiple things, and I was excited for my small business.
We tried as much as we could to help out and make sure that we increase the revenue streams inside of that business.
They're actually going to be hosting hookahs with children at your event in your space. I'm not comfortable with that.
To ever associate us with any type of drug use or abuse, especially involving children, that was just an inaccurate claim.
I think it's better just to part ways.
Move over to bigger and better things.
Sarah.
I was going to tell you I had the invitation, per se, for the event for Halloween that they had put together. So they put a lot of time and effort into planning the party. It seemed very legitimate. There was notes about security. There was notes about no alcohol, food and drink will be provided. So I could tell that they had put in a lot of effort to hosting this event. And although it wasn't a malicious breach on the defendant's part, I understand she hosted a party that had nothing to do with the plaintiffs, that she got into a little bit of hot water. So to be cautious, she was letting them know, hey, I can't host these types of events with a lot of people. It makes the street too crowded, whatever the reason. However, I disagree with you because I would have given them the full $10,000 that they were asking because although not a malicious breach, and I understand her concern after having the incident with the previous party, but that's not their fault.
You believe that the difference between the cost of one venue to another should be ascribed to them. It's interesting, but the $6,000 was to cover a lot of events. This is one event, so...
I see your point now that you put it that way.
Maybe.
I just think if you were going to make them whole, they should receive their expectant damages as well, or whatever they relied on based on the contract.
I accept your opinion
Sure.
and perspective.
Title, Judy Justice.
Want justice? Go to judyjustice.tv.
He says that you and his brother were never married, who is now deceased, with you as the beneficiary.
That's correct. And he said we're not legally married.
All lies. It's going to make a lot of sense in the end.
It already makes a lot of sense to me.
This is Judy Simpson is suing her ex-boyfriend's brother, Cleefers McCowan Jr., for personal property and filing a false police report.
Court come to order. All rise.
Have a seat, please.
Kevin approaches the bench.
Case 2143, Simpsons versus McCowan Jr.
Thank you.
You're welcome.
Ms. Simpson, you lived with Mr. McGowan for, looks like 7 years is what you said.
Yes, ma'am. It was off and on.
What do you mean off and on?
Well, I had another residence as well.
Okay.
And
it's going to get more complicated, I see, than less complicated. You lived off and on according to you, with the defendant's brother, who is now deceased. Yes. It is your claim at one point in your papers that you and the defendant's brother were married.
Yes, ma'am.
He passed away.
Yes, ma'am.
And it is your claim that the defendant owes you money. He was the executor of the estate, and he owes you money for property that he took from the house and for filing a false police report against you, I assume indicating that you took things from the house.
Yes, ma'am.
Okay. Mr. McGowan says that you and his brother were never married, while he indicates in his papers there might have been some sort of ceremony of marriage.
Yes.
That his brother somehow must have told him that he never filed the marriage license, so the marriage was never valid.
That's correct.
Is that correct?
That's correct.
Okay. Well, let's go to that for a moment.
Yeah.
Yes, it's sort of curious and takes me back to law school days. And believe me, that really tests my memory. Were you at the ceremony where your brother married the plaintiff?
No, ma'am, I was not.
When did your brother tell you that there was a marriage ceremony?
I probably heard it just throughout life.
You mean throughout life for how long?
From the time that he had any dealings with her.
So about 7 years ago?
Yes, ma'am.
So you asked your brother whether he was married?
Yes.
How long ago was this?
I would say 4 years ago.
Okay, so 4 years ago, you say to your brother, I understand that you, what's your first name?
Mona.
Mona got married.
Well, so he gave me an insurance document, and I was like, wow, what's going on? What about all this?
He gave you an insurance document that said what?
From the VA indicating that I was going to be the person that gets the money upon if he demise.
If he died,
right? And
you had a VA insurance policy.
Yes, ma'am.
With you as the beneficiary.
Yes, ma'am.
Okay, and so he showed you the insurance policy.
Well, he sent it to me in the mail.
Okay, and
or email or electronic, and so I said, "Wow, what's going on?" So then I started to ask different questions, and he said, "Well, don't worry about that. We're not legally married."
No, you have to tell me. I said to him.
I said to him, so. Doesn't your wife
Isn't she the beneficiary?
I don't want to be involved in all this.
Right.
And he said, I am not married. We went through a ceremony, and you have 10 days to file the
marriage license.
The marriage license in Las Vegas.
Okay.
To solidify the marriage. And then he said, I never filed it. We are not married.
May I?
Just a second. Did your brother tell you that he had ever told Ms. Simpson that he never filed the marriage license?
No, we never had that conversation.
Okay, well, because you say in your answer, sir, that my brother was too smart for that, he never mailed in the license.
Well, he told me because there was a problem between these two. And so we talked about that, and he said, no, I'm not married to her. And he said, you have to file the document, and I never filed the document. And I have a copy of that right here.
Ms. Simpson,
yes, ma'am.
Tell me when this ceremony took place in Las Vegas.
April 2013.
Did you travel there with Mr. McGowan?
Yes, ma'am. We moved to Vegas together.
Who was at the ceremony?
It was no ceremony. What happened was I don't know what this is. What happened was we went to the Justice of the Peace, and the 10 days is not accurate.
No, don't.
I apologize.
Don't tell me.
We had 1 year to go to like a pastor or minister or something like that because we just went to the Justice of the Peace in Vegas. They give you a year to do it, whereas it's, I guess, what I think the term is officiant or something. Officiant has to do it so you can become married permanently.
So you knew that you were not legally married?
Well, it was legal, but it would be official if you don't do another step within a year. And
I understand that, but you never did the other step.
We didn't, only because he was sick, ma'am.
I don't care what the reason was. I don't care if he was watching Yellowstone or because it doesn't matter why.
I respect that.
What? You can get hooked on that.
No, yeah.
I understand.
So
no,
I don't care what the reason is. You knew that your marriage, because it wasn't confirmed, according to you, within a year that you weren't legally married.
Yes, ma'am. And that
okay, just a second. That's all I want to know. That makes my life much easier. Because, Mr. McGowan, I want you to listen to me very carefully. Under what you told me, under the events that you told me, so you should have kept your mouth shut.
No, it's okay.
No.
It's going to be okay in the end. It's going to make a lot of sense in the end.
No, I understand that it's going to make a lot of sense to me. We're going to follow the money. But I just want to tell you and the people who are watching this that when I thought about your answer, that you said your brother was too smart and didn't file the necessary document within 10 days. My view of that scenario was that she could still consider herself his wife, because if he fraudulently, in an attempt to deceive her, didn't mail the marriage license in, she would be the beneficiary. I'm just letting you know that. You understand what I just said?
Yes, ma'am.
Because he committed a fraud on her. He would have committed a fraud, your brother, on her into leading her to believe that they were a married couple and they had the responsibilities and the benefits of a married couple. But she says she volunteered that she knew they weren't married.
Yeah.
So I don't even have to address that.
And it's okay.
Just a second. I know where I'm coming from.
Okay.
So Mr. McGowan, the person that you were involved in for a period of years, on and off, you had your own place, but he was ill for a certain period of time. Was your brother ill?
No, ma'am.
No. Just a second. Key says no. You say he was ill for a great portion of that time.
Met him.
Shh. Just a second. For a great portion of that time, and that you were his caregiver.
Yes, ma'am.
And you were paid as his caregiver by the government.
The VA, yes, ma'am.
By the VA, to be his caregiver.
Yes, ma'am.
Well, that would be inconsistent with being his wife, to be his caregiver. Because if you're a wife, you don't get benefits from the VA. If you are a non-relative and caring for somebody who requires assistance, you may get assistance. And how much was the VA? Just answer my question.
Yes,
this is not my first rodeo.
Okay, I understand.
How much was the VA paying you a month to take care of, what was your brother's first name?
Marcus.
How much were you being paid to take care of Marcus? Because you say that one check you didn't get because of him. It's part of your lawsuit, so you know exactly how much you were paid.
Ma'am.
How much?
$2,057.55.
A month.
Yes,
and when
ma'am.
did you start collecting that?
2014.
Woo!
Caption, coming up.
You are a legal stranger, so you must have filled out forms to say that you were married.
No, I was considered a family member. I was no longer considered the wife, but I was considered...
Well, you're not no longer. You were never his wife.
A courthouse. The Judy Justice logo appears. In the courtroom, Ramona and Clayfors.
Ramona Simpson claims her ex-boyfriend's brother, Clayfors McCowan Jr., threw out her personal belongings. Clayfors is countersuing for damage and stolen property.
Okay, so there was a reason why you didn't continue to solemnize the marriage ceremony that you went through in 2013, because you started to collect $2,000 a month from the VA in 2014 that you couldn't have collected were you his wife. That's a yes.
No, it isn't, ma'am.
Oh.
Receiving the benefits from the VA, you have to be a family member. You have to be related to that person in order to get this stipend pay. It wasn't a regular VA payment, and it's for relatives. You have to be a relative for that veteran.
What are you getting? Oh,
yes, it's true.
Check that,
Full
Sarah.
of stipend pay for the VA, because we're both disabled veterans. It's not like I just had to do this. I loved him, and I care for him, and he was sick the day I met him.
Just a minute, you both disabled veterans?
Well, my disability was not as crucial as his was.
How much do you collect?
I very minimum, because
I asked you a question. That's a very minimum.
Yes.
It's not a number.
Yes, it's $300 and some change. But the thing is, Your Honor, may I speak, please? He was sick from the day that I met him, and I was taking care of him prior for that. This was his idea, because he was familiar with the veterans and the system. This was his idea that we can receive funds, and it stayed right in the household. We were living together. It was stayed in the household, and that's okay with them.
I thought you told me a moment ago that you had your own place.
No, not then, ma'am. Not then, when we moved back from Vegas, because we stayed in Vegas for approximately 3 years. When we moved back from Vegas, he had purchased a home and everything, and it was supposed to be okay. We were going to be together. But he started living another alternate life, which he was very familiar with, because he's introduced him to so many people. I don't even care about that. I still continue to take care of Marcus. It was no longer a romantic situation.
Now you still continue. You had your own place.
I live both places. because he needed me more there than he did when we was living together.
What kind of alternative lifestyle was he doing that he needed you there part-time?
He was seeing other people and
he was
stuff like
seeing
that.
women.
Pardon me?
He was seeing other women.
He was seeing other people, yes,
Okay,
ma'am.
so he was seeing other people.
So-
But you, let me finish.
Yes, ma'am.
But you continued to receive the $2,057. You knew you weren't married. That money was coming directly to you. It wasn't coming to him.
Well,
It was coming to you. At what address?
he was giving me a portion from his bank account, and then when we discontinued everything, there was nothing physical. Then I was receiving my full allotment at that point, but I was still taking care of him, taking him to the VA, taking him to the hospital.
Wait just a second. I don't care. Don't go like this and like this. He's a legal stranger to you, and you're getting $2,000 a month to take him to the VA.
Ma'am, he was not a legal stranger.
He was a legal stranger to you. Legal. He was not your mother, father, brother, sister, or husband.
Ma'am, he was a dear friend of me. He continued to be a friend, honestly.
Well,
and he knows that. We went to several places together.
I'm setting up for myself what is the actuality of the situation. Now, I understand that I was really not prepared for this scenario. I was prepared for somebody, quite frankly, Miss Simpson, who had been defrauded by his deceased brother into believing they were married. She took care of him when he was sick. And all of a sudden, now that he's deceased, his brother comes in, kicks her out of the house, and takes all of his property. That's the scenario. But now I understand that that is not the case, that you knew you weren't married, that for 8 years you collected $2,000 a month for taking him to the doctor's offices, to the vet, to taking care of him in the house, but you understood that he was seeing other people, that you didn't have an exclusive relationship. Now I understand it. And you did receive a certain benefit from that, because when you moved back from Vegas, you went to your own place because he was having an alternative life that had nothing to do with you. At that point, was the money going to his bank account or yours?
It was going to his bank account, ma'am.
Okay. Well, you say that he notified the government. Part of your lawsuit is for 1 month's check that you say, or 2 months that you didn't get. And you say you didn't get it because he notified the VA or somebody notified the VA. I don't care who notified the VA. What I want to know is, with those checks immediately preceding Mr. McGowan's death, going into his bank account or yours that he had?
His. It was going into Marcus's bank account.
Okay, and he was giving you money from that bank account?
Prior to his death, yes, ma'am.
Right up to the time he got sick and died?
Yeah.
Okay,
yes,
and how much would he give you?
He would have given me $2,057. $2,000.
All right.
No,
okay,
you mean total?
No,
I'm sorry.
No. I get it. It was not what I thought, but I get it.
Ma'am, may I
okay,
please
money
say
owed
something?
for the return of property. What property?
The property, which is my funds. I have jewelry that was missing and clothing that I never received because he kicked out his niece and boarded up the house.
Just a second. Was your brother taken to the hospital?
Yes, ma'am.
On what date?
28th of August, 2021.
Okay.
So he was nowhere to be found.
Just what?
He wasn't around.
Just a second.
I did that.
Just a second. Did you take him to the hospital?
I had his daughter to call an ambulance. I got to Marcus's house and I followed him to the hospital. Yes, ma'am.
Hey, well, you want to just answer my question? I actually understand the whole scenario. You understand that I do understand the money part. I get it. So when you say his daughter called the ambulance and you got over there from your house?
Yes, ma'am.
Okay, and who do you live with there?
My daughter and my son.
And in whose name is the lease?
My daughter's, my son, and myself.
So all three are on the lease?
Yes, ma'am.
And how long have you had a lease at that address?
2017.
Okay, so we're talking about 5 years that you've had an alternative address. You have an answer for me?
There is a Veterans Affairs program of comprehensive assistance for family caregivers. It says $2,800 a month, but based on a fee schedule that can change. So the 2057 fits within the range.
And does it define family members?
It doesn't define the family caregiver, only that the VA may appoint someone who's part of the primary family caregivers to the veteran, but it doesn't identify who qualifies as a family caregiver.
As a family caregiver. And that's the act that you were under. But you were not a member of his family.
Yes, ma'am.
You were not a member of his family.
Well, it
Not
goes
a well.
further than that.
Not
Well,
a well. This is not a well. You're living with your daughter, your son, on a lease since 2017. You know he's got an alternative lifestyle that has absolutely nothing to do with you. He was giving you the $2,000 a month. I don't know why. I don't even have to get into
Right,
that.
ma'am,
But
it's
you
up
were
to
not
that individual,
But you
ma'am.
were not a family member. If this is for
It
family,
does go to the veteran to then give the family caregiver, though.
okay, but you are a legal stranger to him. So you must have filled out forms to say that you were married.
No, it's up to that. It's up to that individual, the veteran, and I know how the procedure goes. It's up to that individual. I was considered a family member. I was no longer considered the wife, but I was considered.
Well, you're not no longer. You were never his wife. So if he filled out a form and
okay with that, ma'am, because I could have
Okay, so
went
he had the
further.
right. You were never his wife. He had the right to board up the house, whichever it is, and you weren't living there for 5 years. You had a place. So if you had clothes there and your jewelry, what were your clothes and your jewelry there? If he was
Because
fooling around with other women, why would you leave your clothes and your jewelry in the house?
Okay, ma'am. The thing is, no one has came to the home as another woman in that home. I was always there. He has no proof or evidence that I was not there. So basically, I had their clothes there because I stayed there. I lived there.
Forget it. You were more than compensated with $2,000 a month. What's next?
Caption coming up.
I don't believe that you leave any valuable jewelry at his house.
I was there most of the time, honestly.
You don't need valuable jewelry if you're taking care of a sick person.
A courthouse. The Judy Justice logo appears. In the courtroom, Ramona and Clayfors.
Ramona Simpson is accusing defendant Cleefers McCowan Jr. of throwing out her personal belongings.
Okay. Do you have any of her property?
No, no, ma'am.
Did you dispose of any of her property?
I didn't. She had no property
Just
there.
a second. I don't believe she had any property there either, anything of value.
And I did.
Okay.
Can I?
Excuse me.
I did find what the VA considers a caregiver. So if you're a spouse, son, daughter, parent, step-family member, or extended family member of a veteran, or if you live full-time with them, or if you're willing to live full-time with them if they designate you as the family caregiver.
So technically,
if you're willing to live with the veteran full-time, you could be qualified as a family caregiver, but it's up to the veteran to declare their own family
caregiver, if you live there full-time.
Yeah.
Yeah. But she stated if you were willing to, and I was always willing to.
Okay.
And because
good. I don't feel as if you were shortchanged, madam, at all. And I don't believe that you had anything of value in the house. So your case is dismissed. Now we're going to get to the second part of your claim. You say she took property from the house?
Yes, ma'am.
What property?
She took jewelry, guns.
What jewelry?
Chains, rings, cufflinks.
Show me.
Entire.
Show me. How am I going to figure that out? You have photographs of things?
Yes, I have some photographs here.
This is so sad.
So sad. You have to put a period and end it. You had a good thing going for 9 years.
Ma'am, the money was paid in the arrears, first of all. So me not getting paid for, and this is really not a big issue to me, what he's saying, because they're all lies, and I'll tell you the truth.
Just say, I'm not saying anything, madam. All I'm saying is you have no case, because I don't believe that somebody who lived in a lifestyle, as you've described, as you've described to me, which is you have your own home, where you're on a lease since 2017, where you said to me he had an alternative lifestyle, but I still took him to his VA appointments. I took him, and I was his caregiver, but I lived with my daughter and my son. I don't believe that you leave any valuable jewelry at his house.
I was there most of the time, honestly.
You don't need valuable jewelry if you're taking care of a sick person.
But
Can I see?
I was stating we're also friends, ma'am.
I've decided your case.
I respect that.
Clayfors hands a document to Kevin, who brings it to Judy.
This is just what had happened to looking for everything that was taken in there.
I don't care. Who cares? What are you showing me? You're showing me that the place is a mess, that somebody went through it?
I'm showing you what...
I don't care.
Okay.
I don't care. Prior to his death, when had you seen your brother last?
I had seen him about 5 days prior to that.
You live close by?
I was living in San Diego at the time, and he lived in Highland, which is it's 79 miles up the 15 freeway.
Okay, so 5 days prior to the 5 days prior that you saw your brother, when had you seen him before?
We see each other quite frequently. We have family barbecues, this, that, and the other. I'm retired. I go.
Okay, would you return these to him? These don't show me any jewelry.
Okay.
It shows me that the house looked like it was picked through.
Okay. Thank you.
What else?
So quite frequently.
That's it. Did you get a VA benefit from your brother for his insurance
From
policy?
the life insurance policy.
Yeah, that's from the VA.
Yes, ma'am.
And how much did you receive?
$2,600.
Who paid for his funeral?
I did.
How much was that?
11 or 1,200.
So you took some of the insurance money and paid for it?
Yes.
Did he have any other valuable asset?
He had quite a bit of stuff. It's in probate as we speak.
Oh, so case is in probate
It's
now.
in probate right now as we speak.
Oh, great. So I don't have to deal with it. Your case is dismissed. We're done. Thank you.
This court is adjourned.
Ramona.
You know what? I have a lot of respect for the judge, but she didn't listen to me.
Well, I'm happy that the judge made the decision that she made.
He's a habitual liar.
Thief. My brother died, and within a half a day went over and burglarized the house.
This is something that he can laugh about, and he's going to go and tell the whole world that I'm still a liar. I'm still a this, that, and the other.
There is quite a bit of items that belong to me that this person stole.
That you can love someone and not be married to them. You can help someone and not be married to them and making love to them. I was genuinely there to help Marcus because I love Marcus.
The devil. You don't want the devil, the devil.
He barred me from the funeral. I didn't fight it because the respect I have for his family and for Marcus. I could have went there. No. I said, you know what? I won't be there.
I hope that she crawls back in the rat hole she came out of and does whatever she does.
Judy and Sarah.
You know what was interesting in that case, Sarah? When I read the complaint and the answer, I had a whole different vision.
Me too.
Of what the arrangement was. And based upon what the defendant wrote in his answer, that his brother, with regard to the marriage, to his brother telling him, I'm too smart, I didn't mail in the papers.
Read like fraud a little bit.
Right.
But she was in on it. She knew. She didn't complete the steps.
She didn't complete the step for a different reason,
Sure.
but she knew
that they weren't legally married.
That they weren't legally
Which
married.
changes the whole game from a legal perspective.
Right. Certainly the fact that the case is currently in probate made my life a lot easier. Anyway, it should be a warning signal when you get married out there, folks, and you have a marriage license, because I performed enough weddings to know you have to seal it, sign it, put a stamp on it, and usually put it in the mail within 3 days of the ceremony. So brides and grooms, make sure you put it in the mail together, or watch the officiant put it in the mail.
Can never be too sure.
Right.
Title, Judy Justice.
Are you having a family dispute? Go to Judy.
You owned your own plane, and he hit a cone and caused substantial damage to the propeller and the engine.
A plane hits a traffic cone.
Those cones are made of plastic.
I don't care. You don't have to be a genius to figure out that the plane flew perfectly fine before you hit the cone.
This is Judy Justice. Albert Lee is suing pilot instructor Ed Meyer for damage resulting from Ed moving his plane.
Court come to order. All rise.
Have a seat, please.
Kevin approaches Judge Judy.
Case 2145, Lee versus Meyer.
Thank you.
You're welcome.
Mr. Lee, you are an amateur pilot?
Yes, I was yes.
And you owned your own plane?
I bought it to train in, yes.
When did you purchase the plane?
In, I believe, April of 2021.
Did you buy it new or used?
I bought it used.
What kind of plane is it?
It's a Cirrus SR-22, 2010 type Golf.
What did you pay for it?
I paid $420,000 for it, I believe.
Is there a mortgage on the...
Yes, there is.
How much?
It's $2,204 per month.
You paid $425,000 for the plane?
Yeah, I put a down payment on it. The outstanding balance is $347,000. The payment per month is $2,022.
I don't need the payment per month. I just wanted to know what you paid for it and how much you put into the plane.
Yes.
The defendant is a pilot, licensed pilot, and he was giving you some training on the plane.
Certified flight instructor, yes.
It is your claim that at some point, you'll tell me when, that the defendant was operating the plane by himself. You weren't there, and he was moving it from one part of the FBO to another part, and he hit a cone and caused substantial damage to the propeller and the engine. And while you had your insurance did cover some of it, according to you, it did not cover all of the expenses, and you want Mr. Meyer to be responsible for that. So it's a simple question. Mr. Meyer, do you remember the date that you were operating the plane when Mr. Lee was not there?
Yes.
What date?
It was in April sometime.
April of 2022?
Correct.
Do you remember the date, Mr. Lee?
Yes.
What date?
It's April 22nd.
Would that sound right?
Yes.
Okay. And from what I read in the papers, Mr. Meyer had in fact taken you out, but then the weather got bad. You decided that you would make your way home and that he would get the plane home when the weather was better.
Correct.
And that was on or about April 22nd.
I flew home on a commercial flight the day before on April 21st.
And you stayed with the plane.
Yes.
Now, would you agree, Mr. Meyer, that if in fact you hit an object with the plane, it would be your responsibility?
Yes.
Because it would mean that there was some sort of negligence involved.
Right.
And then there would be the issue of damages. Mr. Lee, you were not present when this incident happened.
I was not.
Not present.
I was not present. I was able.
No, you were not present.
I was not present.
That's the answer. Was this witness present?
He was not present, but he was the one responsible for procuring the evidence on what happened and how the propeller was damaged.
Who does he work for?
He has his own flight school, and he also manages my airplane in terms of the maintenance and the upkeep.
Okay. Could you step up, please?
A man rises.
Tell me your last name.
Last name is Williams.
Mr. Williams, were you charged with gathering the evidence to determine what happened to the plane on the 22nd of April?
Yes, I was.
And you're paid a monthly fee by the plaintiff to manage his plane.
That's correct.
Did you retain the defendant as an instructor, or did Mr. Lee?
That was both decided by Mr. Lee and Mr. Myers to fly for him.
But you
He's
did
an
not.
independent contractor. At that.
You did not have anything to do with, as the manager of the plane, you didn't have anything to do with selecting Mr. Meyer.
I did select Mr. Meyer to fly with Albert.
You did?
Yes.
Okay. Because were you the one who introduced him to Mr. Meyer?
That's correct.
When, Mr. Lee, did you start to work with Mr. Meyer?
It was probably a prior flight where we flew to San Francisco for a business meeting I had. After that, I believe it was...
In what month?
Roughly about the same month.
In April?
Yeah, in
so
April.
You didn't
maybe.
know him for a long time?
No, not very long.
I'm going to get back to you in a minute, Mr. Williams. Prior to the defendant, had anybody else been an instructor for you?
Yes. Clinton was my primary instructor, but I flew with some other instructors as well.
But it wasn't until the month that this incident occurred that you had been connected with the defendant?
Correct.
Okay. Now, sir, how were you advised that the plane that you managed was in an accident?
I received a phone call from Ed saying that there was a problem.
From whom?
From Mr. Myers, that there was a problem with the aircraft after he taxied and did the run-up and returned the aircraft back to Signature in Las Vegas. We notified and contacted a
Did you ask, what you would usually ask is what happened?
Yeah, what happened?
Just a second, and what did he say to you?
He said that he was having instrument problems with the aircraft and he wasn't able to take off, so he returned the aircraft. At that point in time, I contacted a service center. I had 2 technicians go out and look at the aircraft, see what was wrong. At the time, the technicians found that they...
Don't tell me what they found.
Okay.
You can't tell me what they found. It's hearsay.
They send me pictures of the damage of the propeller.
May I see the photographs?
Clint hands a tablet to Kevin, who brings it to Judy. She reviews a photo of a damaged propeller on it.
Okay, so that's a fresh damage.
Correct.
Can I scroll this?
Yes, you may.
Or it's just one? Okay, so you have a picture of that. You have a picture of the cone that has a slice in it.
Correct, that's the object he hit. We also have a video showing the plane taxi and hitting the cone at the
I'd like to see that as well.
Okay.
Okay, let's see what we got.
As you can see where the...
Just one second, Mr. Meyer, is that a fair and accurate representation of where the plane was before you moved it?
It should be on the last, on the far left side of that Learjet.
Okay.
Footage of a small plane running over a traffic cone, then dragging it.
Oh. Mr. Meyer, do you see that you went over a cone?
It's interesting. I didn't even notice there was a cone.
You may not notice it, but you see it now.
Yes.
Okay.
Caption, coming up.
Your hitting of the cone caused damage to that plane. I mean, you're not talking about flying a 747. You're talking about a little single-prop plane. Yeah, they like those planes you put together, we used to put together with rubber bands. I wouldn't put my behind in one of those planes for all the money in the world.
Whitney grins. A courthouse. The Judy Justice logo appears. In the courtroom, Albert, Clint, and Ed.
Albert Lee claims pilot instructor Ed Meyer is responsible for damage after Ed moved Albert's plane.
Okay.
In all of my years of flying, which is pretty significant, I was an airline pilot too, I've never, ever experienced that in my life.
Okay, but you see it now.
Yes.
It's not an on purpose. It's, you know, that's why they call them accidents. We don't mean for them to happen.
Right.
We don't mean for them to happen, but you do see that the plane did hit a cone.
Right.
Okay, and I have photographs of the cone that has a slice in it, and the same kind of slice from one of the propellers. Now, so that's conceded that Mr. Meyer did, in fact, hit the cone, which in all probability caused damage to the plane, caused damage to the propeller. Now, tell me about your insurance.
The insurance covered the propeller. They covered the teardown of the engine. When something strikes the propeller, they have to tear apart the engine, make sure the components...
Do you have those?
I
that
do.
paperwork for me? I'd like to see it.
Okay, so here is the insurance covered portion, and here is my covered portion that I had to come out of pocket to pick up the plane.
Okay.
And I can explain both invoices.
Albert hands documents to Kevin, who brings them to Judy. She reviews them.
And if you flip to the last page, that'll have the total. Insurance covered about 60-something thousand for the propeller and the engine teardown.
Okay, so the damaged propeller, Mr. Williams, causes you to have to take apart the engine, fix the engine if there was damage to the engine. Am I correct?
That's correct. The FAA requires anytime you strike an object with a propeller, the engine has to be inspected in the component parts. So they
Component parts of the engine.
Yeah, with the damage, potential damage of the engine. Internal damage that could be caused by striking an object.
Okay, the insurance covered how much, sir? Mr. Lee?
It's, sorry, it's on the invoice 60, I think it was 63,000, 64,000. It's on the last page.
The last page shows
a deposit of
$63,000.
Yes, that's it.
The deposit was 40, balance due was 23. Did the insurance company pay the entire 63?
This entire
$63,000. This is what was submitted to them.
Yes.
Okay, now I'd like you to take a look at this, Mr. Meyer. No, I'm going to actually ask Mr. Williams to take a look at this document. These are the items, Mr. Williams, that Mr. Lee says were uncovered. I would like you to go through all those items and tell me which of those items relate to the engine and which do not.
Okay, is this the total?
Carefully, because I'm going to potentially ask you about each individual thing, because there looks to me like some things that bear no relation to an engine.
Okay, so most of the items that you see that are airworthiness on the airframe are the items that need to be inspected or replaced from the teardown. So your item 1, item 2, 3, 4, item 5, 6, 7, 8. These are all items that the repair shop goes through the engine and assesses whether it needs.
Well, tell me how the brakes would be impacted.
I don't think
would be impacted by hitting the.
Which invoice?
And I don't know, but how brakes would be impacted by hitting a nose cone.
Brake lining, I don't know what that is.
Okay. Yeah, some of these items, Your Honor, such as one of these items, the brake lines, as you pointed out, is probably not part of the.
Well, that's what I want you to go through, sir.
Okay.
Do you understand? I want you to take a marker, a pen, and circle, because I don't know a whole lot about
Okay.
airplanes, but I know a little bit about airplanes. I know what's routine maintenance and what has to be taken care of because a plane either falls on its nose or falls on its tail, both of which I've experienced.
Well, this is a small invoice. This is not your, this is a 12.
Mr. Williams, don't ask him. I didn't ask you to have a conference with him.
Okay.
I asked you to look at that. You're the management company. I want you to strike those items that are not related to this accident and go through them very carefully because...
Can I make a comment? Okay.
Nope.
To you directly?
Nope.
Okay.
Can I ask you something?
Can you ask me something?
Yeah. Well, he should tell you those cones are made of plastic.
I don't care. They're heavy cones. You hit the cone. And the plane flew perfectly fine before you hit the cone. It didn't run after you hit the cone. You don't have to be a genius to figure out the cone caused, your hitting of the cone caused damage to that plane. I mean, you're not talking about flying a 747. You're talking about a little this is a single prop plane.
Right.
Yeah. They're like those planes you used to put together with rubber bands. I wouldn't put my behind in one of those planes for all the money in the world.
The only items I can see, Your Honor, are 2 items that may not be related to the accident, items 7 and 8.
Okay, may I have that back, please, sir?
Clint hands the document to Kevin, who brings it to Judy.
And you are familiar with planes, sir, is that correct?
Yes.
Okay. So what you're saying is item...
The circled item.
7 and 8.
Correct.
So we have...
There's a couple of invoices.
We have right and left main gear, but which is 143 plus 270 plus 66. What about item 9? Pitch, trim, jab, nut, loose. What is that?
Probably what they do during the inspection and the tear down, they go through the aircraft itself, make sure it's airworthy. So they probably caught another item or 2. You can probably put that on item that's wasn't part of the accident.
The big ticket items, adding up all of these items, Mr. Meyer, that probably have no relation to the accident which you caused.
Correct.
Still bring the total amount to more than this court's jurisdictional limit. Can you tell me, sir, why your insurance, Mr. Williams, let's go back to you. You manage this plane. Can you tell me why Mr. Lee's insurance didn't cover all the damage to the plane?
A lot of the prospective renters or instructors that everybody uses, or we used in this case, carry their own insurance for this type of incident. Their insurance covers basically downtime, loss of operation, or in this case...
You mean Mr. Meyer?
Yes.
Would have his own. Do you have your own insurance?
No.
No.
Caption coming up.
Don't you do a check to find out if they have their own insurance before you recommend someone?
He had insurance, but it was lapsed.
If you have insurance that's lapsed, then you have no insurance.
Yeah, that's correct.
So you're lucky that he's not suing you.
A courthouse. The Judy Justice logo appears. In the courtroom, Albert, Clint, and Ed.
Albert Lee is accusing pilot instructor Ed Meyer of hitting a cone and damaging his plane. Ed says Albert was already paid by his insurance company.
Mr. Williams, you were the one who recommended
That's
Mr.
correct,
Meyer.
we did.
Don't you do a check to find out if they have their own insurance before you recommend someone?
He had insurance, but it was lapsed.
Well, that he didn't have insurance. I get that all the time. If you have insurance that's lapsed, then you have no insurance.
Yeah. As a flight school, our instructors are required to carry the insurance.
Okay, but that didn't happen here.
That's correct.
So you're lucky that he's not suing you because you managed the plane for him. And you recommended him, Mr. Williams, you know. When you have a management company that manages your plane, they're supposed to make certain that if you have a certain kind of plane, that you have pilots certified to fly those kinds of planes. And if they give me a list of pilots and those pilots aren't certified to fly the kind of plane that I might have, then it's the fault of the management company.
In this case here, the plaintiff and the defendant were working together as far as their payment and the fees they were going to charge.
Well, that's okay. That's okay. They may have been working head to head. I mean, it was Mr. Meyer's fault, but I'm just telling you that Mr. Lee relies on your advice. What business are you in, Mr. Lee?
I do commercial real estate. I sell shopping centers and office buildings.
Okay, that's not his business. That's why he hires you. And if he hires you, he asks you for recommendations as to where to get the plane repaired, for an instructor. Now, the fact that he may pay him independently, he's relied on you for information, so I suggest, Mr. Williams, that you tighten up your ship a little bit. Mr. Meyer, you're responsible to the plaintiff for the damage that you caused his plane. Why did you let your insurance lapse?
It had lapsed. I just didn't even realize the fact that it had lapsed. I just realized the fact that when this came about, that's what happened.
Well, when was the last time you paid premiums?
Probably about a year before that.
Anything else you want to tell me, Mr. Meyer? You owe him $10,000. You caused the damage. You have to fix it. Judgment for the plaintiff. We're finished. Thank you.
This court is adjourned.
Outside the courtroom, Ed, then Albert, and Clint.
I understand her point, the fact that what she saw.
I thought she's very fair.
These cones are made out of plastic.
It's hard to believe. It sounds like a gunshot when he hit the cone and triggered several warnings. And for him to say he had no idea, it's a little bit hard to believe.
They don't have much weight to them.
With the loud bang after you hit it, it's quite obvious that you should have stopped and shut down and inspect the damage.
There normally is never a cone at the 12 o'clock position. They're at the left side and the right side.
They place cones all the way around the aircraft, and it's part of your responsibility as a pilot in command to do a walk around pre-flight, make sure there's no object in front of your aircraft.
When I taxied out halfway down, that's when I recognized there was an ICAS message that came on.
I finally got it back, and no more student pilots, so won't let any CFIs fly for a while.
Judy and Sarah.
You know what I thought about in this case, Sarah? That lay people have to look at something, lay people, and while I'm a judge and have certain expertise, I have no expertise in reading slips that show what's been done on a car or an airplane or a train or a boat.
But we have common sense.
But we have common sense. And your brakes are not part of an engine. You know, you have an engine job, and then you have a brake job, and you have a...
I saw where you were going.
different kind. And, you know, if you have an accident that impacts on the right driver's door, if you put in a new wheel casing in the left rear door, well, that has nothing to do with an accident.
Probably just an oversight. He did state that those two items were not part of, you know.
He did.
He did at the end, but it just feels a little uneasy when they try and slip those things in there, that just common sense doesn't ring true, that it comes from the science.
Yeah, you know, front, back, you know, the head of a horse, the tail of a horse, it doesn't fit in. And there's really no difference between not having insurance when you're driving a car and not having insurance as a flight instructor. Yeah, that's pretty serious.
I would think there would be a more rigorous check on that before you get behind an aircraft, the wheel of an aircraft.
Absolutely. You would think that there would be. Yeah. There's a flaw in the system someplace. Okay, I'm glad nobody was hurt.
Yeah.
Title, Judy Justice.
Want justice? Go to judyjustice.tv.
You collided with her car on the driver's side.
Yes, Your Honor.
He had cut through the intersection. He was not in the walkway.
I just went like around here and through this crosswalk.
In a crosswalk?
Yeah, I was in the crosswalk.
You know when they're telling a fib?
How?
When their mouths are moving.
This is Judy Justice. Is suing Joseph Simonet for car damage after Joseph's 15-year-old son hit Carrie's vehicle.
Court come to order. All rise.
Judge Judy enters.
Have a seat, please.
Kevin approaches.
Hello, Judge.
Good morning.
Case 2138, Cargill versus Simonet.
Thank you.
You're welcome.
Judy turns to Carrie.
Miss Cargill, you and the defendant's son had an accident while you were driving your car, and Mr. Simonet's son was driving his electric scooter.
It was like a skateboard, a one-wheel skateboard.
Judy gestures at a young man who rises.
Tell me your name.
Jacob Simonet.
Describe this vehicle that you were riding on.
It's got 2 spaces for your feet. Has one in the back, one in the front.
Now try to look at me. I'm trying to see you. Trying
There's
to
one in the
go
back,
like this.
one in the front, and then there's a big wheel in the center. And you put your feet on either side, and then it balances, and you ride it kind of like a skateboard.
Oh, I actually
had a
have
feeling you
picture
might
of
need
myself riding on one of those for about 30 seconds.
Yeah.
We bought it for one of my grandchildren years ago, but it's motorized.
Yes.
It has a motor.
It's electric.
And how fast does it go?
Tops out at about 17 miles an hour.
17.
Yes.
That's pretty fast. Are you required to drive that on the street where pedestrians walk or where cars ride?
On the sidewalk with the pedestrians.
Sidewalk.
Yes.
Do you drive it on the sidewalk?
Yes, I do.
Do you ever drive it in the street?
I do not.
Now you're going to tell me what happened on the date of this incident, which was August 17th.
This year, yes.
Okay.
Yes, I was going south after work, and I was going to crossing through the intersection. I had the green light.
Is there a chart?
Yes. Yes.
I'd like to see it.
Yeah, I was crossing the intersection.
You're the blue car.
I'm the blue car. And I had the green, it was going, and Jacob had cut through on the red into the green and slammed into the side of my car. He had cut through the intersection.
So he was in the street where the cars travel?
Yes.
Not on the sidewalk?
Right. He was not in the walkway.
Okay. Jacob, I want you to walk up to that sign and show me where you were when you and the plaintiff collided.
I was about right here.
You were in a crosswalk?
Yeah, I was in the crosswalk coming through and about
Okay,
right.
is that what, Jacob, is that what the police report is going to indicate? That you were in the crosswalk?
I don't know.
Well, I assume that there is a police report. Is that correct? Police report's going to tell me where the debris was, I assume. The debris is either going to be in a crosswalk or it's going to be in the street. Where do you think it's going to be?
Some of it was in the street.
Show me the street that you're talking about.
About like right
No,
here.
put your finger on it. Don't go around where it's
About right here.
right there. That would be in the middle, right?
Mm-hmm.
That would be in the middle of the street where the cars travel, not in the crosswalk.
Yeah.
Yes,
Judy turns to Joseph.
it's easy.
Sure.
How old is he?
15.
15. I've had a whole bunch of those who are 15. You know when they're telling a fib?
How?
When their mouths are moving.
He's a pretty good kid.
All of my kids are pretty good kids. But you can always
Figure
tell.
it out, huh?
Yeah, you can usually tell. Is this your first only?
Both, first and only.
First and only. Oh, well, she probably had some experience with that anyway.
A little bit.
A little bit. Okay, and this happened at what time during the day?
I believe it was about 4, a little after 4, 4:30.
So it was light out.
Yes.
You collided with her car on the driver's side.
Yes, Your Honor.
Okay, on the door of the driver's side.
The fender.
Fender.
Yes.
Side fender?
Yes, side fender.
Okay, not the front of the car.
The front fender of the car.
Front fender of the car on the side. I'm talking about it was the side or the front?
The side.
Side. So you collided with her.
Yes.
Because cars don't move sideways.
Yes.
He could have been quite seriously injured.
Yes, he could. He hit the side of the car and he flew up onto the hood and then kind of rolled across the hood, hit my windshield, and then fell onto the ground. And when I stopped, he jumped up, appeared at my window, and apologized, and then asked me if I was okay.
What did he say?
Just said he was sorry. And then he asked me if I was okay. And then I asked him if he was okay. And then he asked me if I was okay. And it went back
So
and
far,
forth
is that
a little
right?
bit.
Yes.
Okay.
And which I was very impressed by, that he was more worried about me than anything else. I moved my car out of the road, onto the side of the road. There was an EMT that was across the street from us, and he came over and assessed him if there was any more damage. He got some road rash and things like that, but he was not seriously hurt, at least that we noticed at the time.
Do you have the police report?
I do.
I'd like to see it, please, Kevin.
Carrie hands a document to Kevin, who brings it to Judy.
Thank you.
You're welcome.
She reviews it.
One witness said that he was right next to you and that you went past him and that the light was red. His light was red, which is why he was stopped. That's what I'm reading. He did say that his light was red when the kid initially passed in front of him. Did you get a copy of this police report?
I've seen it, yes.
Explain to me, would you put on this again and leave that one on because that's the version that I believe. Would you walk over there and explain to me what cut the corner was, what you were doing? It talks about cutting the corners. So I want you to understand, I believe that, based upon what I'm reading here, I believe that.
Mm-hmm.
So now I want you to show me how you cut the corner.
So I was coming to this one, and I went through, and instead of going here and just going through the sidewalk, I just went like around here and through this crosswalk.
What's cut the corner?
Cut the corner here, right there.
You mean just that little space is what you're talking about? You cut the corner?
Yeah, I went from about.
I want you to understand, I believe that you were in the street. I believe you were in the street, not in a crosswalk. So let's run through that again. Would you please show me what cut the corner was?
Went through here, I came here, and I cut here. So right there, I cut the corner.
Judy gestures for Jacob to return to his table.
He is a nice boy, Mr. Simonette.
Thank you.
Caption, coming up.
You know what my father told me when he gave me my first car? I think I was 17, but it was like a tank. He said, because if you get in an accident, I want you to be surrounded by 4,000 pounds of steel.
And later today.
Your claim is that you won a whole bunch of money in some gambling thing. I just want you to tell me how much you won.
Before taxes or after?
Both.
A courthouse. The Judy Justice logo appears. In the courtroom, Carrie, Joseph, and Jacob.
Carrie Cargill claims Joseph Simonette owes for damage after his 15-year-old son hit Carrie's car while riding an electric skateboard.
Okay, the police determined that based upon the eyewitness testimony that the pedestrian, Jacob, is at fault and believed to have crossed the intersection before having the right-of-way. The vehicle had the green light. In any event, do you have photographs of your car?
Carrie with a photo.
This happened in August, and you were called to the scene by your son, is that right?
Correct.
And you got there, you know that he was a little banged up, but thankfully
He was in
okay.
an ambulance when I arrived, but shortly after, yes, he did walk out of the ambulance and suffered some injuries, which I have pictures of if you'd like to see them.
I'm sure he was banged up. He had bruises from falling off the...
From being launched from the vehicle after the collision, correct.
Okay. You know, he was really lucky that she wasn't going faster.
Correct. Could have been much worse. We were
Could have been much
thankful for his health and the outcome of the incident.
You're right. Okay, can I see an estimate to fix your car, please?
A document.
Thank you.
You're welcome, Judge.
Judy reviews it.
What kind of a car do you have?
A 2015 Equinox Chevy?
You had full coverage on the car, is that right?
Yes.
But with a $1,000 deductible.
Yes.
So if you put this through to your insurance, you have a $1,000 deductible.
Yes.
Right? Anything else you want to tell me, Jacob?
No.
Do you still ride one of those things?
It's broken. I didn't get a new one, no.
It was destroyed in the accident.
You know what my father told me when he gave me my first car? I think I was 17. He bought me the oldest, ugliest car, but it was like a tank. All my other friends were getting these nice, cute little cars, and this one was like an old person's tank Cadillac or something. You know, we're talking 50 years ago. And I said, why do I have to have this car? Everybody else has cute cars. He said, because if you get in an accident, I want you to be surrounded by 4,000 pounds of steel. That's pretty much the lesson that I've sent out there. 4,000 pounds of steel. One and only, surrounded by lots of steel. Judgment for the plaintiff in the amount of $1,000. Thank you, we're finished.
This court is adjourned.
Carrie, then Joseph.
Overall, I'm happy.
She had some fault due to hitting a pedestrian in a crosswalk.
It was surreal, like out of the movies.
Your heart stops, and all you can do is look for the car keys and panic and get there as fast as you can.
I am so glad that he was okay.
I remember just flying through the air, and then I was on the ground, and I got right up.
Be very careful.
Count your blessings and enjoy every moment that you have, because things could change in an instant.
Sarah and Judy.
I know these electric scooters and skateboards are very popular, but even before this case, I tried to look up any rules, laws, regulations. There are a few for electric motorbikes and things like that, but far fewer than I would expect for a machine that can go up to 17 miles an hour when you're 15.
I think that you're right. I think that since those things have become so popular, there really have to be enforced rules. And parents, and this is a very nice father and son, but I've seen kids weave in and out of cars. It always looked like an accident waiting to happen.
Yeah, and this one could have ended in a real tragedy.
He was lucky, and his father knew he was lucky.
Yeah.
Case 21-24, McPherson versus Hall. All parties, please step forward.
Gerald McPherson is suing his ex-girlfriend, Natasha Hall, for money she received during their relationship.
Mr. McPherson.
Yes.
How old are you, sir?
40.
What kind of work do you do?
Home care aid?
Independent, or do you work for a company?
Home care aid agency.
For an agency?
Yes.
How long have you been working for them?
About a year now, but I've been doing home care for about 3 years.
prior to working for them the past year, and you're still working for them, is that right? Was there a period of time when you were unemployed?
Not more than maybe 3 weeks, but since I know Ms. Hall.
No, I don't want to know about Ms. Hall.
No, I'm telling you my employments that since I've lived in her residence, I've always worked. I worked at the zoo, Census Bureau.
Don't try to think ahead of me.
Okay.
There was a period of time in 2020, according to you, that you became homeless and were living in a shelter.
Yeah,
and that was in what month in 2020?
In June. So if I can explain the situation. I was living in a house that a slumlord wasn't doing the repairs. So I ended up forcing his hand, him selling the property, and the new landlord and my...
Could you look at me when you're talking?
I'm sorry. The new landlord and my other ex, they kept the property. I moved out. I went to a shelter because I didn't want nothing to do with her or the...
You're talking about her?
No, ma'am.
Well, then don't keep pointing to her. I'm asking you...
I'm just pointing in general. I'm not pointing at her.
You actually pointed
I'm sorry.
to her. When you were in the shelter, were you employed?
Yes, for the Census Bureau,
Okay.
doing the census. I was actually out in the field knocking on doors. I was an enumerator.
So you were not working in home health care, you were a census taker?
At that time, yes.
And did you have a child living with you?
Yes, well, not in the shelter, no. I could not have my daughter in the shelter.
How old is your daughter?
10.
And where is her mother?
She's deceased.
Where was your daughter living when you were in the shelter?
With my mother.
Is she living with you now?
She's been with me since June.
In a new apartment?
Yes, I moved in August 1st.
She goes to school from your apartment?
Yes.
Okay. In 2020, you became acquainted with Miss Hall, and there came a time shortly thereafter, uncross your arms, and there came a point shortly thereafter when you moved into her home.
In August, yes.
Of 2020. And you remained in her home until what month and year?
August of 2022.
And in what month and year did you regain custody of your daughter?
June of 2022.
So there was a period of 2 months when you and your daughter lived in Miss Hall's home.
You could say that, but...
Well, I'm saying that because I just asked you a question about timeline.
No, because me and Miss Hall was going through our dispute about this money, my daughter was staying with my grandma. I only brought my daughter there on certain occasions.
When I say you regained custody of your daughter, was that a court order?
Yes, I have it right here.
Just a second. Was the child removed by court order from your custody?
It was removed because the house...
Don't tell me because.
Yes,
it was yes.
Yes.
I have lots of things to do today.
Okay, I'm sorry.
Child was removed from your custody.
Because I didn't have nowhere to live at the time.
Was the child removed from your custody before you moved into the shelter?
She was removed because I was in the shelter.
Did you take her to the shelter?
No, I was not allowed to because there's no men.
So at that time,
female
did she go and live with your mother?
Of course.
Was that by court order?
No, it was
brought her to your mother?
Yes.
May I see the court order that involves custody, please?
Here you go.
I'm not getting an answer.
This is the court order, and this is these two forms.
Gerald hands a document to Kevin, who brings it to Judy. She reviews it.
Now, that court order is the current.
Shh. Okay, so the child was placed with the Commissioner of Social Services in Pennsylvania. And the child was placed in kinship foster care, which is a program that I am very familiar with the child's paternal grandmothers. So in June of this year, the child was returned to your custody. At some point in August of this year is when you and the defendants separated and you left the house. This is your claim. Your claim is that you won a whole bunch of money in some gambling thing. What kind of gambling thing?
Caption, coming up.
I don't want to go back to the year, Gimel, sir. All I want you to do is tell me how much rent you were paying her.
To be honest, I had to...
I don't know. I want you to be dishonest with me.
A courthouse. The Judy Justice logo appears. In the courtroom, Gerald and Natasha.
Gerald McPherson claims his ex-girlfriend, Natasha Hall, wrongfully spent the money he gave her for rent.
Your claim is that you won a whole bunch of money in some gambling thing. What kind of gambling thing? I want you to look at me when you talk, not at the papers.
I was going to...
In what kind of gambling thing did you win money?
I betted on 25 games.
What 25 games?
NBA, college, hockey.
Okay, and you bet where?
On FanDuel. It's an app called FanDuel.
Okay, and you won?
Yes.
I don't
25
understand the whole thing. I don't want to learn the whole thing. I don't care about the whole thing. I just want you to tell me how much you won.
Before taxes or after?
Both.
Okay, $36,742, and after taxes, $26,889.
On what date?
So I won the bet on the 28th. It came into my account.
28th of what?
January.
Of what year?
This year.
And you had been living with Miss Hall for 2 years?
Prior, yes.
Okay, and you were working according to you all of that time?
Yes.
Okay, good. Were you paying any rent to Miss Hall?
I have receipts.
Yes, I want to see those. How much rent were you paying?
So when I met Miss Hall...
I don't want to go back to the year, Gimmel, sir. All I want you to do is tell me how much rent you were paying her.
To be honest, I had to pay
I don't know. I want you to be
rent.
dishonest with me.
Half her rent is like $425, and she had me pay half the gas and half the electric and half the cable.
Her rent was $425?
No, it's $850. I had to split it. We're paying half and half.
Miss Hall?
Yes, ma'am.
What kind of work do you do?
I do customer service.
And who else lives in the apartment with you?
My children.
How old are they?
14 and 13.
How large is the apartment?
It's a 2-bedroom.
And the total rent is $850?
Yes, ma'am.
There's no subsidy involved?
No subsidy at all.
Okay. And you have a lease?
Yes, ma'am.
How much did you charge, if anything, Mr. McPherson as rent?
$425.
Well, that doesn't quite sound fair, does it? Did she make a figure with you of $425?
I paid more than that. I paid $425. That's half of the rent. I paid half of the electric and half of the internet bill.
There are 4 people in the house.
Yes.
Right? Why is he paying
we're
for...
only
Why was he paying for half the rent?
Oh, my children don't work, and his child didn't work either.
His child wasn't with you?
The child came with us in June, but she had visitations on weekends.
I don't care if she has visitations. Your children live with you.
Yes.
They don't have to work. They're your children. They're not his responsibility. Okay, I just want to know where everybody's head is at. There came a point, Miss Hall, when Mr. McPherson gave you $6,000 in cash.
No, not in cash.
Check.
No, both of them was wired. One was directly wired into our Bank of America account.
When? Just a second. When?
The first transaction was on January 31st. The second transaction...
January 31st of?
This year. And the second transaction was the next day, February 1st. $12,000 total.
Do you acknowledge Miss Hall receiving $12,000 in your account from Mr. McPherson, or do I have to look at his records?
I do not acknowledge. He gave me $6,000 and $4,500.
$6,000 and $4,500, Mr. McPherson. Does that sound right?
No, it's not right, and I'm going to show you.
Let me see your bank record.
All right, hey,
and
sir.
Let us assume that it's $6,000 and $4,500 that he gave you in this year, 2022.
Yes.
Is that correct? Okay. Let us assume for the moment that you're correct, because you're suing for $6,000.
Yes.
Right?
Yeah, because the first initial $6,000 was 8 months' rent. That I'm not.
Let us assume that you are correct, that he gave you $6,000 and $4,500. I'm taking you at face value. In January and February of 2022.
Yes, ma'am.
What was the money for?
That he gave me?
Yes. The 2 different amounts of money.
Yes.
There's a $6,000 and a $4,500.
$4,500 was for me to pay my car note off. And
hey, just a second.
Go ahead.
Why would he pay your car note off?
He said he wanted to.
Oh, no. That's ridiculous. Ms. Hall, let me just check.
Can I say something?
No.
He even wrote that on there for your car note.
No, you said in January he won a bet and cashed it out. A few days later, he gave me money via Cash App to catch up on his rent and as a thank you for helping him out. I don't see anything here about gift for a car note in your answer.
So he gave me the money for the car note, and as far as the Cash App money, he gave me money lots of times. So, yes.
No, I'm talking about the $6,000, madam.
Yes.
Let us assume he gave you $4,500 to pay off your car note. That's what you said.
Correct.
What's the $6,000 for?
The $6,000 was for us to move.
For who to move?
Me and him.
Show me.
The $6,000?
Yeah, show me that there's proof. He says he gave you the money according to his complaint to hold for him.
Yes.
Shh. Just a second.
A document.
Yeah, February 3rd, he gave you $6,000. This just says he gave it to you.
Yes.
And
And he told me to hold it so we can move.
Well, you didn't move.
No,
you didn't. Shh. He told you to hold it for him so that you could all move.
No.
So who could move?
So me and him and our children could move.
Well, that's what I just said.
I apologize.
So that we could move.
Correct.
But you didn't move together.
Correct.
So you have to give him his money back. That's simple.
Thank you.
Just a second. That's simple. If you say he gave you the money so that the two of you could move and that event never took place, but he in fact moved out, you owe him $6,000.
But then he agreed.
Just a second. That's an easy. Okay. Do I have to deal with anything else? Money for lost wages, rent, utilities? Forget it. He paid all of that with the $4,500 when he paid off your car note. Come on, let's get it together. Lost wages. What are the lost wages for?
But then I had to take off from work because of the PFA, and I had to take off from work to go file out the court and things like that. But in the midst of him saying the $6,000, he didn't pay rent. He didn't pay all of his rent.
He paid off your car note. You owe him $6,000. Your counterclaim's dismissed. We're finished. Thank you very much.
Okay.
This court is adjourned.
Natasha.
Well, I don't agree with the judge's decision. I don't think I owe him the money.
That's what women do.
Because he gave me a gift and he didn't pay rent.
I also spent $2,000 on her in gifts.
What's done is done.
I'm taking a break from women for quite some time now.
Sarah and Judy.
So I'm glad that the plaintiff's daughter didn't have to go into the larger foster care system and was able to stay with plaintiff's mother. But I was curious that if this was a temporary slip up and he wasn't going to be permanently without housing, why wouldn't he go with his daughter to his mother's house? I was surprised you didn't ask him that question.
You're right.
Yeah.
You're right. Yeah. That's a curious question.
To me, it just seemed like it might have been a better situation to crash at your mom's house with your daughter
With
for
your
a while,
daughter.
but
I'm not sure whether I have that whole story because they continued the child in care for a period of time, at least for almost 2 years, because he didn't have custody of her while he was living with the defendant.
well, one easy part of the case was that he was owed his $6,000 back.
That
so
was
that's
that
all we
was
had to deal with.
Yeah, that was easy. Once she got her hands on that $6,000, and he was no longer in the picture, it was hard for her to give up.
Yep.
Title, Judy Justice.
Have you been cheated?
I got kicked in the head by a horse. I'm out of work. They said I have a cognitive deficit.
She had horses that were unsound. Her young horses were jumping and running in paddocks with huge boulders. It was unsettling. You understand what I'm saying.
This is Eppenbrock. He's suing horse breeder Jessica Austin for the deposit on a horse.
Court come to order. All rise.
Judge Judy enters.
Have a seat, please.
Kevin approaches.
Hello, Judge. Case 2136, Dippenbrock versus Austin.
Thank you.
You're welcome.
Judy turns to Diane.
Dippenbrock.
Yes.
You bought a foal, which is a baby horse, in utero, which means that the horse had not yet had this foal, but you wanted to place an order for it, and Miss Austin is in that business.
Correct.
You entered into a contract. By the way, what is the gestation period of a horse?
Roughly 340 days.
And at what period in the horse's pregnancy did you enter into this contract with the plaintiff?
Roughly 3.5 months into the gestation.
Okay. Did you have a written contract?
Yes, Your Honor.
I'd like to take a look at it because this is a contract action. And it is your claim that you made a substantial deposit, over $3,000, for the horse, that when the horse was born, it did not meet the specifications of this contract. You wanted your money back. The defendant says that's not true,
Correct.
that the horse did meet all of the requirements of this contract. The one specifically that you're referring to is something in this contract, which I will read, I assume, that says that the horse must be, once born, insurable within the first 2 days or 48 hours of its birth, and that this horse was not insurable within 48 hours, and therefore you decided to terminate the contract. That's your position, correct?
Yes, Your Honor. I request-
And it's your position that the horse was in fact insurable. You say you can prove that because you did in fact get insurance on the horse within 48 hours of the horse's birth? And
So
no, don't.
Part
Your
of that
position is
statement
that you met the conditions of the
Yes.
contract.
Yes.
Okay.
Judy reviews the contract.
Okay. The deposit for 25% of the purchase price, the seller agrees to hold the foal off market exclusively for the buyer until the foal reaches 48 hours old and is deemed insurable. Well, does that mean that foal is taken from the mother and transferred?
No.
So the foal stays with the mother until it's how old?
I choose to wean at 6 months because they seem to be better adjusted if you wait until that period.
Okay, and it's not that you can't get insurance, it's that a live, healthy foal is defined as a foal that is deemed insurable at 48 hours old. And if the mare fails to produce a live, healthy foal, then the buyer may request a refund of the deposit or a credit towards another purchase. Okay, so the foal was born when?
June 9th, 2022 at roughly 5:30 in the morning.
Okay, your case, your proof.
Okay, so I had to find out the foal was born through Facebook.
Okay, whatever.
Never notified me, and then I went to see the foal when it was a day old on Thursday.
1 day old?
I mean, well, not even 12 hours old, basically.
Okay, so it was not a day old, it was 12 hours old.
Correct, I'm sorry, 12 hours old. June 10th, she told me the vet would be out at 9:30 in the morning to do the routine foal exam, and I had requested to be notified of the results.
Just tell me about the contract. The foal is born alive and is how old now?
She turned 5 months old on the 9th of this month.
Have pictures of her?
I do.
I'd like to see.
Jessica grins, then hands photos to Kevin, who brings them to Judy. She reviews photos of a dark-colored baby horse.
Oh, she's beautiful.
Thank you.
Have you seen her?
I have.
Recently?
No.
Would you show the plaintiff these photographs?
Kevin brings the photos to Diane, who reviews them.
Looks perfectly healthy to me.
I couldn't get insurance when she was...
Just a second. Looks perfectly healthy to me. And I'm not an expert, but you would say that that horse looks pretty healthy.
Yes.
Okay, great. So now the horse is 12 hours old, and tell me the rest.
So at 48 hours old, I submitted the vet report to 8 insurance companies, and they all declined to insure the animal.
Just a second. You submitted what report? Let me see the report, and let me see what you received.
Okay.
Did you furnish her with a report within 48 hours?
I furnished her with what the vet gave me. He did the vet exam at 24 hours old, but he had to draw blood and send it to a lab.
Okay.
And wait for that
just
to
let me. This first thing is dated June 12th, 2022. And this laboratory is sending a report to you, and it seems that they put the horse on a course of antibiotics initially for 1 day because something came back high. But it says, I do not believe all foals should automatically get antibiotics. However, I stand by our decision to treat what turned out to be a completely normal and healthy foal. We can pull follow-up labs to be sure, but her behavior since the blood sample backs up the lab results. Her behavior since the blood samples, what does that mean?
So for a foal to be considered doing well behaviorally, it needs...
What are you a doctor of, first tell me?
People. Internal medicine.
Okay.
For people.
Okay.
I brought an expert witness veterinarian.
Okay. So now I have these test results, which I don't understand, and I'd like to see your reports from the insurance companies.
Diane hands a document to Kevin, who brings it to Judy. She reviews it.
How long was the foal on antibiotics?
She received 2 doses, one the day the vet came out, and then one the following morning before he got the blood test results back.
Which, when the blood test results came back,
they were normal.
They were normal?
Yes. And he said, don't give any more antibiotics. She does not need them.
And this report that you have from one insurance company, or from actually all of them, say underwriters have declined to provide coverage at this time and will reassess when the foal is off antibiotics. Well, the foal was off antibiotics within 2 days.
Mrs. Austin told me she was on antibiotics for 3 days, actually. And then
Well,
claimed that
either
she
2 or
started
3 days, but then the test results came back normal.
The insurance companies, each of them will wait a certain amount of days. So that particular one wanted to wait 7 days to reassess after the foal had been off antibiotics. A few of the companies were 30 days, and I think one was 14 days.
Well, but that doesn't matter. All you need is one.
I was taking a risk without having an animal that's uninsured, and I wasn't ready to.
This is problematic for me because if I put a deposit down on something that I really wanted, and within 2 or 3 days, any question with regard to whether or not the animal was insurable or healthy, if my intention was to honor the contract, I would say, let's see if the results are normal or abnormal. Now, the results came back that the foal was perfectly healthy. So unless you had, in my view, something preconceived that you wanted out of this deal for some reason other than insurability, it's your horse.
I signed the contract based on the fact that she could be insured. The year before, I purchased another in utero, and that foal was insured at 24 hours old, and with the same type of contract. I wasn't going to enter
that's
into
all
a
right,
contract.
but that's all right. You understand what I'm saying
I
to you.
understand,
You
but I-
understand what I'm saying to you, because my problem is, after I made the deposit, according to you, some things came to my attention that gave me anxiety. This is before the foal was even born. I learned about several of plaintiff's horses that had to be put down. She had horses that were unsound, lame, and missing eyes. Her young horses were jumping and running in paddocks with huge boulders. I also found out that she tried to sell the mare that was pregnant with my foal to a friend of mine. It was unsettling.
Correct.
Right. So I'm trying to just put this in chronological order for myself to understand whether there was a true breach of this contract.
Caption coming up.
You have a counterclaim.
Yes, Your Honor.
For what?
When I originally got the notification from the court, I got kicked in the head by a horse on July 4th, and they had done testing. I'm out of work. They said I have a cognitive deficit.
What does that have to do with what you want?
Later.
So this is a picture of the car before he painted it?
No, ma'am, that's after.
Oh, it doesn't look bad.
From afar.
Listen, when you're born in 1964, everything looks better from afar.
A courthouse. The Judy Justice logo appears. In the courtroom, Diane and Jessica.
Diane Deppenbrock is suing horse breeder Jessica Austin for the deposit on a horse. Jessica is countersuing for breach of contract.
The foal is born on the 9th of June.
Correct.
Was given a dose of antibiotics on the 10th of June.
Correct.
Because they were suspicious of something before the blood was drawn.
Correct.
Given another dose of antibiotics in the morning of the 11th.
Correct.
The blood results come back on the 12th, which indicates that the horse was totally normal, and you advised her, correct? That the
I
test
immediately
result...
forwarded the email to her, correct.
Okay, now the foal is 50 hours old, and you're told that the foal is totally healthy. I'm not sure that I'm comfortable with your position that there was a material breach of this contract. I think that a perfectly healthy horse was born, and it was within a reasonable period of time, may not have been 48 hours, but if they were being very cautious in starting the course of antibiotics. You're the vet. Stand up and tell me if I'm not seeing something. The vet who saw the horse, was that you?
It was not.
Okay. Evidently decided that to be very cautious, they would await the blood test result on the horse, on the baby, and start a course of antibiotics that could be stopped if the blood tests came back normal, which they did within a day. Oh, I don't think that there's been a material breach of this contract by the defendant. I think that you're obligated. If she wanted specific performance, that's fine, but you're not entitled to your deposit back.
I have an email from the insurance company from the 21st when she finally told me that the foal was insured.
Just a second.
I can't take that risk for 2 weeks on an animal. That
No.
Get insurance on.
No. But your problem is, it wasn't 2 weeks. Your problem was, it was less than a day within adding it on to that 48-hour period. And I have to determine whether that was a material breach of the contract. Certainly, if the lab results came back that show that there was any deficiency in the horse, I would say absolutely you're entitled to your deposit back. But they did not. They came back and they said that a vet wanted to be very cautious but the vet turned out to be wrong.
My contract didn't state anything about a vet.
I'm telling you, I don't find that one day was a material breach of the contract, because if you had then on the third day sent the normal blood test results out to the same insurance company, the insurance company would have found that the horse was insurable.
They wouldn't, because they wanted to wait 7 days until the horse was off antibiotics.
Then you wait 7 days. That's still not a material breach. She's not asking you for the rest of the money.
So something would have happened in those 2 weeks, I would have been out $9,000?
That is not
just a second.
accurate.
You were not. You weren't going to take the horse until the horse was 6 months old.
I wasn't going to take the horse if it wasn't if it couldn't be insured.
Well, it could be insured. It turned out that the vet was cautious and you were wrong. And I believe that you had already made a decision in your mind.
I had not already made a decision.
Well, I find that there's not a material breach. You don't get your deposit back. Now, horse is yours. You have the counterclaim.
Yes, Your Honor.
For what?
$1,500 for my lawyer costs and another $100 to file the counterclaim.
For your lawyer's costs for what?
When I originally got the notification from the court, I got kicked in the head by a horse on July 4th, and they had done testing. I'm out of work. They said I have a cognitive deficit that they're working.
What does that have to do with what you want? I mean, I'm sorry about that, but what does
I
that
obtained a lawyer to represent me in court because I didn't know if I would be capable of representing myself.
Oh, well, but you are perfectly capable of representing yourself. You don't get your deposit back. So now you have a perfectly healthy horse that you can sell, and hopefully sell for the same amount that you sold it to the plaintiff for, and pay your attorney's fees. Do you understand? Because she lost her deposit. I don't think that there was a material breach of a contract with an extra 1 day to get normal lab results back. Your case is dismissed. We're done. Thank you very much.
This court is adjourned.
Jessica.
As the judge read from the contract, as the seller, I assumed all risk on the foal until she was 6 months old.
Quite a lot of money to make an investment in, and you want to make sure that your assets are covered and that the horse can be properly taken care of if something does come up.
Therefore, the argument that the buyer would lose anything if something happens to the foal is inaccurate.
I'm really happy with the 2 horses that I have, and I'll continue to stick with the ethical breeders that I know.
And the insurance that we obtained was based on the exam at 24 hours old. Therefore, we have proven that we upheld the contract.
So one interesting thing about that case is, as I was looking at the calendar of what day the horse was born and when the vet came out first and when the results came back, the horse was born on a Friday, and then the vet came out Saturday, and I was surprised that any lab sent labs back on a Sunday. So in a business that's so dependent on something you can't control when the horse is going to give birth, why would the defendant put in her own contract a 48-hour, such a tight window for insurability for the horse? Maybe it's standard practice. I don't know standard practices for horses or anything like that. But
you're right, it's a tight window. Yeah. And my guess is, although I could have asked the question, probably standard in that industry, I'm not sure. But it's interesting to note that in contract law, unless time is of the essence, there has to be some sort of material breach. And, you know, in this case, if the defendant had not had a vet come out and look at the horse for a week, well, that's a different story. She had a vet come out immediately. The vet was super cautious. Vet turned out to be ultimately, thankfully, mistaken that there was nothing wrong with the horse. Got a clean blood test, but the plaintiff had already determined that she had buyer's remorse with regard to this deal. There was another agenda there because the horse looked beautiful as it turned out, 5 months old, and a beautiful animal, and it was perfectly clear within 60 hours.
And the defendant seems to love it now and very proud of it, so it's in a good place anyway.
Yeah.
Case 2134, Wimberly versus Mahara. All parties, please step forward.
Tina Wimberly is suing auto body worker Robert Miera for a refund of a 1969 VW Bug paint job.
Miss Wimberly, tell me about this car that you have.
So I have a 69 Volkswagen Beetle. I've had the car for about 20 years.
Where did you buy it?
In Salt Lake City, Utah.
Is it a bus or a bug?
It's a bug.
My goodness, I remember everyone had one of those cars. The whole world had those little bugs when they came out. Except me, scared to death. Okay. Anyway, you've had it for a long time and you try to keep it restored. Do you have a photograph of it?
I do, yes,
I'd like
ma'am.
to take a look at it, please.
Caption coming up.
You acknowledge as unsatisfactory because you said,
I didn't
I'll
acknowledge.
fix
I said I'd take care of it. And a good gesture to try to make things work with her. I did not deny her any kind of service or say, go get lost until she started cursing at me.
No.
She didn't tell you she was cursing at me, you know?
A courthouse. The Judy Justice logo appears. In the courtroom, Tina and Robert.
Tina Wimberly claims auto body worker Robert Miera owes a refund on a 1969 VW Bug paint job.
As you're getting that, the case is simple. You want your money back for a bad paint job that you say that Mr. Miera did on the car.
A photo.
So this is a picture of the car before he painted it?
No, ma'am, that's after.
Oh, that's after?
Yes.
Oh, it doesn't look bad.
From afar.
Listen, when you're born in 1964, everything looks better from afar. Okay, and that's an interesting color. Do you have a photograph of what the car looked like before you took it in to the defendant?
No, ma'am.
Okay.
But I have pictures of after the bubbling that it's doing.
Yeah, I'll take a look at it.
Tina hands photos to Kevin, who brings them to Judy. She reviews images of bubbles in the purple paint on the hood of the vehicle.
Okay. Have you shown these pictures of the bubbling to Mr. Miera?
I have, Your Honor.
And you've seen them, sir?
Yes, ma'am.
Okay, so this is the story. You brought your car into Mr. Miera to paint it. He gave you a price. The price was?
Originally, it was $3,500.
What did you ultimately pay him?
$6,500.
Okay, so you paid him $6,500 to paint it. When had you brought him the car?
In January.
Of what year?
2021.
And when did you pick the car up from him?
May of 21. I was moving from Albuquerque, New Mexico to Louisiana, and as May got closer and closer, I kept telling him, I'm leaving, you
Okay,
know.
the car was there from January until May.
Yes, ma'am.
You picked the car up in May. Was it ready in May?
Yes, ma'am.
When she picked it up?
Yes, it was ready when she picked it up.
When had you painted it?
Probably painted it at the beginning of April.
No, ma'am.
Is that when you started sanding it down, I assume?
Oh, no, she actually sanded the car down herself.
So the car was completely sanded when you got it?
No, it wasn't completely sanded. We had an agreement that she was supposed to help me repair the car. You know, that's why I gave her a price that I did, because she wanted to help and learn how the process went.
Okay.
So
just look up for me.
So I gave
1969 VW Bug.
So I gave her
found
the
it on the
chance
classic car.
to
Okay.
learn the process.
But you say it was ready when she picked it up?
Yes.
Okay. And she showed you the pictures of the bubbling on the car?
Yes.
And she paid you $6,500?
Yes.
Well, I would have a trouble with that bubbling myself.
Of course, I understand.
So?
I offered to fix the car.
And?
She didn't want to bring it back.
Well, that's trip far to bring it back.
Well, that's all I can do. I can offer to fix it, you know.
Well, by offering to fix it, you acknowledge that I would say as a layperson, this is not what I would expect.
Well, I said
this was not what I would expect if I paid $6,000
of course,
to paint a car. And what steps, because this bubbling seems to be in various spots of the car, so it's impossible, and I'm a layperson, you know, I went to law school.
Yeah.
I didn't go to mechanic school or painting school, but I've lived a long time, and when you have spots like this on anything, either a wall or a car, you can't just spot fix it, right?
No, you can spot fix it.
It's all over the car, Your
Just a
Honor.
second.
Yeah.
Well, it's been my experience that you can't spot fix it because this is a bright color. It was done now almost a year and a half ago, and you're not going to be able to match colors because car colors like bright ones fade. So if you just do it in spots, it'll look like a leopard.
Well, not necessarily.
Not necessarily.
There's ways to adjust the paint, the color of the paint.
Well,
you can tint
Mr. Miera, she is not bringing the car to New Mexico when she now lives in Louisiana.
Yes.
Because that would cost her. I know I transport cars of mine when I move around, and that's very expensive. Not quite as expensive as the paint job, but close, which would mean she would have to incur a substantial expense to get you back the car from a paint job that clearly was unsatisfactory. Well, that you acknowledge as unsatisfactory because
no,
you said,
I didn't
I'll
acknowledge.
fix
I
it.
said I'd take care of it in a good gesture to try to make things work with her. I did not deny her any kind of service or say, go get lost until she started cursing at me.
No.
She didn't tell you she was cursing at me, you know?
Well, Mr. Miera, if what I say you would have to do would be to start over, sand down the car, which she did herself, according to you, because if she sanded
she got a
the car...
discount for working on her. She worked on her own car, so she got a discount for working on her own car. So she had her hand in it as well.
That's terrific. You're going to give her back her money, $6,500. Judgment for the plaintiff. We're done.
This court is adjourned.
I think when she transported the car, the moisture and the climate that she took it to may have played a factor in.
I totally disagree with what he said because I took it from his house, put it in another van.
And having the car bubble like that, but you know, I'm not sure. There's a lot of things that could happen.
And the moisture with what he's claiming, there's no way.
I tried to rectify the situation and it didn't work out, so.
Time to get it looking good again.
Sarah and Judy.
You never got back to me about how much the 1969 Beetles were worth. And I was surprised because reading the papers, reading a $6,500 paint job, I was surprised at that. Like, that was very expensive to me. But then when I looked up how much the cars are worth, they're worth anywhere between $12,000 and $35,000 for a nicely kept, maintained vintage car, similar to the one that I saw briefly in the photos.
I'm sorry for not getting back to you.
It's okay.
I got caught up.
But I think you made the right call because after the paint job, we saw the damage or the bubbling, and I know that you or I would not be satisfied with that paint job on an asset that was worth that amount of money.
Of course.
So I think the right thing happened.
I'm sorry. Forgive me.
It's okay.
I'll try not to do it again.
You.
Title, Judy Justice.
Want justice? Go to judyjustice.tv.
Before you could move into the house, you had to upgrade the electric.
Correct.
You were dissatisfied with the company.
I had it signed off, but it was signed off when the job was half done.
That's your problem. You want to sign off when something's half done? Fine. I wouldn't sign off when my hair was half dried.
This is Judy Justice. Are suing John's former client, Cynthia Booth, and her fiancé, Dwayne Burnley, for posting damaging reviews.
Court come to order. All rise.
Have a seat, please.
Kevin approaches the bench.
Hello, Judge.
Why are you,
Case
Kevin?
2079, Frazee versus Burnley Booth.
Thank you.
You're welcome.
Mr. Frazee, you are an electrician by trade.
Correct.
And how long have you been in that business, sir?
Since 1986 as a license and 1978 as an electrician.
Now, maybe a decade ago, you're going to give me the exact year, month and year. You were called to do a job for this lady. Your last name is?
Booth.
Miss Booth. And you did an electrical job for her. We'll go into it more fully in a minute. When you were doing that job, you brought in a helper. This gentleman whose name is Mr. Burnley.
That's correct.
And before you brought in Mr. Burnley, I gather from the papers, Mr. Burnley did not know Miss Booth. Would that be a fair statement?
That's a fair statement, but he did not bring me in. I was actually just driving down the street, and I'm new to the mountain, and I drove by and saw Mr. Frazee there, and I was...
Listen, this is not Gone with the Wind. This is not War and Peace. I asked you a simple question. Before you were brought in on the job, you didn't know Miss Booth.
That's correct.
Right, and that was about 10 years ago.
Correct.
Since that time, since you were brought in on the job, you and Miss Booth have gotten to know each other a lot better.
Correct.
And I assume that by a lot better, that the two of you live together.
Correct.
And you've been living together for how long?
Since November.
Of this last year,
yes.
November of 2021. But prior to that, you were social friends.
Correct.
And that social friendship started when first introduced to her at this job. It's the first time you met her.
Oh, that's the first time I met her, correct.
Correct. This is your problem, and this is the nature of your lawsuit. You allege that you did a job for Miss Booth almost a decade ago, and you came to ascertain that Miss Booth and/or Mr. Burnley had written some negative reviews about your company, currently wrote negative reviews about your company based on work that you did 10 years ago.
Yes.
That's your complaint. And you asked them to take them down. First they did, then they didn't. You found other ones posted in different areas. Now, Mr. Burnley Are you a working man, sir?
Yes.
What kind of work do you do?
I'm an electrical contractor in Big
Okay. Now, at the time that you first met Mr. Frazee, did you have your own company?
Yes.
You had your own company.
Yes.
In what year did you do Miss Booth's job?
I did it on April 30th, 2013, Your Honor.
That's not correct.
That's not correct.
Shh. Month and year, you say you did the job.
The job was done on May 9th of
what?
2013.
Okay, so we're off by a month. Is that right? I don't care. You were talking about 9 years ago.
Correct.
Now, tell me something about the job. What was the nature of the electrical job that you were doing?
An older home needs to have at least a minimum of a 100 amp service. Ms. Booth's home had a 70 amp service at the time. She was purchasing it, and that came up on the inspection report to replace that, which I was engaged to do.
So far, correct?
No.
Well, now I'll have your version. Did you have to upgrade the electric?
I had to upgrade due to a homeowner's insurance.
Okay,
That's
well,
what they required.
What's the difference in what he said? He said that you had to have your electricity upgraded, and it came up in the inspection report.
It did not come in an inspection report.
Well, then how did they find out? Who found out about
with my policy.
What do you mean you were honest with your policy?
Well, they asked me what year the house was and what amperage it had, and I said 75.
And your insurance company said to you it has to be 110.
100.
Or 100.
Yes.
Before you could move into the house, for one reason or another, you had to upgrade the electric.
Correct.
Okay, and you hired Mr. Frazee to do that.
Yes, they were my friends.
I don't care whether he was your friend or not. If he was your friend and he was a vet, you wouldn't have hired him to do your electrical work.
Of course
He was
not.
your friend and he was an electrical contractor.
Right, correct.
And when he came to your house to look at the job, did he come alone or with a helper?
Alone.
Once you change the ampage in a house, do you have to get somebody from either the county or the city where you live to sign off on it? That's either a yes or a no.
Yes.
And once Mr. Frazee did that, modified the ampage, did you have an inspection?
Yes, Your Honor.
Do you have that inspection?
Yes.
I'd like to take a look at it.
And the job was not...
I didn't ask you anything.
Okay.
That also includes Mr. Burnley's inspection.
Just a second.
I'm sorry.
Don't volunteer. I'm old. I get confused. I try to keep these things very linear so even I understand them.
Judy reviews a document.
This is the inspection sign-off on the work that you did in 2013. Have you seen it? Yes, of course you have.
No.
Well, show it to them. You do remember that you had to have an inspection afterwards.
Of course.
Ms. Booth.
Of course.
Okay, it's just common sense. If you didn't have the work done and you said to your insurance company, I had the work done, the insurance company would say to you, show me proof that you had the work done, otherwise we're not giving you insurance.
Correct.
So you know you had an inspection after he completed the work.
It wasn't after the work.
The work was never...
Shh. I didn't ask you anything.
Okay.
But I will answer for you.
She wasn't...
You can.
Okay.
You can. So the insurance company accepted your word that the work was done?
Yes.
Okay. Can I have that back, please?
And I did tell them I had it signed off, but it was signed off when the job was half done.
That's your problem. You want to sign off when something's half done? Fine. I wouldn't sign off when my hair was half dry.
Caption coming up.
I'm saying to you that it was nasty and malicious. And it wasn't until the two of you were coochie-coochieing that all of a sudden we got negative reviews about a job they did 9 years before. That's ridiculous. It's mean-spirited.
A courthouse. The Judy Justice logo appears. In the courtroom, John, Cynthia Frazee, Cynthia Booth, and Dwayne.
John and Cynthia Frazee claim John's former client, Cynthia Booth, and her fiancé, Dwayne Burnley, slandered their business. Dwayne is countersuing for filing a wrongful lawsuit.
Now, my next question to you is, after 2013, did you perform electrical work for Miss Booth in her house? That's either a yes or a no.
Yes.
Now I'm going to ask you, what was the nature?
I don't know.
What do you mean you don't know?
I don't remember.
You mean, just a second, you remember the work that you did when Mr. Frazee was there in 2013, when you were with him. but you don't remember the nature of the work that you did for your girlfriend in 2018?
I'm pretty sure it was a panel upgrade.
Just a second. I want you to think. What kind of work did you do for Miss Booth in 2018?
It must have been the panel upgrade that I did at her house. I changed the 100 amp out to a 200.
Look at me.
Because that would be.
Look at me.
I'm sorry.
So you changed the 100 amp. Shh. This is not my strong suit, and I have to tell you something. Of the 100 million people who are watching this, they're going out to get a cup of coffee right now. You changed the 100 amp that he had done in 2013 to a 200 amp. You upgraded it in 2018.
And put a surge protection system
And a
in her
surge
house.
protection.
Yeah, now I do recall.
Great. When was the first negative review that you can show me written about your company? Now we got what's going on. Now I have it
Your
clear.
Honor.
Do you have it clear?
I think a little bit more fuzzy than you, but clear enough.
Do you have it clear?
I have it clear now.
You have it clear? Well, just to make it crystal clear, Mr. Frazee did work at Miss Booth's home in 2013. It was electrical work. It was electrical work performed by him with the help of Mr. Burnley, because in order to get a homeowner's policy on her new house, she had to upgrade to satisfy, according to you, only insurance.
Correct.
That's what you say, from 70 to 100 amps.
Yes.
Look, this whole little thing at my age, I'm learning. Now, evidently, they liked what they saw in 2013, and that materialized into a romance. Good for you. And in 2018, I assume he was living there?
No.
When did he move in?
November of.
November of last year.
Yes.
Okay. But you were dating in 2018?
Yes.
Yes. In 2018, Mr. Burnley, not with the help of the plaintiff, replaced and upgraded the 100 amp to 200 amp, which is much better because I know that I have 200. That's, you have to plug things in. It's 110, 220, right?
Yeah.
110, 220. And he put in a surge protector. Now, even I know what a surge protector is. Correct me if I'm mistaken. That means if there's an overload, a lightning strike, whatever it is, it protects it so the whole board doesn't fry and everything turns off, and then you have to replace all the wires go zzz. Am I right? Right. So he upgraded the system and touch of necessity what Mr. Frazee did in 2013. No question, had to do that. Now I'd like to see the negative reviews and when they started.
The first one we found was in 2019, Your Honor.
Well, are these in order? This was...
That's the most current one that was in February of 2022.
Did you write this? Frazee Electric, he was supposed to do a panel change and never put rods in and fried my electronics in my home and garage opener. Left such a mess and never cleans up.
That's correct.
Did you write that?
Yes, I did.
When? In what year?
It's about 3 years ago.
3 years ago, 2018.
Approximately.
About when he changed the electrical
Yes,
system. Just a second. Okay. About when he changed the electrical system. All right, then you wrote something. I will not even write this company 1 star due to the unprofessionalism in completion of work. Hired this electrician to do a 100-watt panel, never grounded, never finished, and left a mess. He's known for not cleaning up. Had to hire another electrical contractor that was most professional. Now, when did you write that review?
About the same time.
2018?
Yes, on a different review.
That was a different one. And you said that you had to hire another electrical contractor.
Yes, I
to
did.
finish the job. And who was that?
That was DMB Electric.
That was him?
Yes, I called
Just a second.
2 competitors.
Just a second. In what year did you call them?
Oh, this was...
No, in what year did you call him?
2013.
After he left, you called them?
I called 2 other contractors.
Just a second. Did you end up using Mr. Burnley?
Yes, I did.
Okay. So back in 2013, you were dissatisfied with this company.
Yes.
Let me follow this. 2013, you were dissatisfied with the company. You called another company.
2 other.
Just a second. You called another company, but the county had signed off on your job.
Yes.
What you say in your answer is that they signed off erroneously on the job. Well,
yes.
I have to take at face value they're signing off that the job was completed. And I assume You got your homeowner's insurance.
Yes, I did.
After he left and after you had the county sign off.
Yes.
Yes. Okay.
But they...
Now, just a second. Now, don't tell me a but.
No.
Now, 5 years later, because this was written in 2018.
Correct.
5 years later, you're now dating Mr. Burnley.
Correct.
Who's now living with you.
No.
Who had... Well, you say you moved in 2021.
Oh, 21.
Yes.
Yeah, who's now living with you. You began dating in 2018.
That's correct.
And Mr. Burnley, who is now living with you, and in 2018, you woke up one morning and said, who now has his own electrical company, woke up and said, 5 years ago, Mr. Frazie's company and he did not do a professional job in my panel. And now we're dating. And now all these negative reviews come, not in 2013 when we, Sarah, you have Yelp and all those things in 2013?
I'm not sure if I can get back that far, but I could search.
And I wasn't aware of Yelp.
I don't care what you were aware of.
Okay.
You mean you woke up in 2019 and found out that you could give a star or a review? That's the first time you found that out? I don't believe you. I don't believe you.
Well, it's
I just
true.
want to tell you something. I don't believe you. I don't believe that when you want to go to a restaurant, Miss Booth, and it's a new restaurant, you don't take a look on your computer and say, I wonder how many stars it got. I wonder if there are any reviews on this resort.
Yes.
Well, then you were smart enough to do this.
My sons are in IT, so they
I want to tell you something. I don't believe you.
Okay.
Because I'm older than you are. And I know about this, and she can tell you I'm an idiot on the machine.
Well,
I don't buy it. And I don't buy, actually. Yeah, it is.
I can't see any of her reviews.
No.
But there are reviews on Yelp of his business that all are very positive.
I have them if you'd like to see them.
I will look at
And
them.
I have negative reviews that says the exact same thing what Cindy posted.
Just a second. You don't understand what I'm saying to you, Mr. Burnley. I'm saying to you that it was nasty and malicious, because if she was unhappy with the service, it would have been posted in 2013, 14, 15, 16, 17. And it wasn't until the two of you were hoochie-coochieing that all of a sudden we got negative reviews about a job they did 9 years before. That's ridiculous. It's mean-spirited.
Caption coming up.
All those positive reviews that you posted, did any of them have to do with people that you're sleeping with? That's a question.
No,
No,
of course not.
Of course not.
I'm not that kind of girl.
A courthouse. The Judy Justice logo appears. In the courtroom, John and Cynthia Frazee, Cynthia Booth, and Dwayne.
Electrician John Frazee has accused his former client, Cynthia Booth, of posting damaging reviews years after the job was completed.
It's mean-spirited.
That's not correct.
Just a sec. You say it's not correct.
Well, I'm
I'm looking
saying-
at the timeline. I'm looking at an inspector's report.
Right.
Who is a disinterested party, who signed off on an electrical work. I'm listening to Mr. Burnley, who 5 years later did work that replaced his work from 100 amps to 200 amps with a surge protector, and all of a sudden, you start writing negative reviews about their company. That's the timeline. And if you want to try to fill me in and make me feel as if I made a mistake, I'll give you 30 seconds to do it.
Yes, we started seeing each other in 2014. And my sons are in IT administration, and they had told me, Mom, you don't know
Don't
about
tell me
Yelp?
what your sons, don't tell me what your sons told you.
I didn't know about Yelp or Google reviews back at that time, because I'm not computer savvy.
You want to know something? I don't believe you. I don't believe you. I'm almost 80 years old, a lot older than you are. And I know that if I want to look something up, which I do occasionally, I look something up and I say, did so-and-so eat at this fish restaurant? It's a new place, it's a new town. I'm going to go there and take a look at it. I know how to do that.
I know.
And I'm an idiot, and I'm an idiot. And if you just found it out, if you just found out how to do it, then there was no reason for your first review to be about his company.
No.
About a job that was done.
There's 91 other reviews I've posted.
Just a second. Positive or negative?
Positive.
Are you sleeping with any other electrician?
No, I'm not.
Just a second. That's the end. All those positive reviews that you posted, did any of them have to do with people that you're sleeping with? That's a question.
No,
No,
of course not.
Of course not.
I'm not that kind of girl.
What I'm telling you is the timeline doesn't make sense. These nasty reviews written about a job that started 9 years before, in this case, 6 years before, now that you are sleeping with a head of an electrical company, don't make sense. And my nose tells me if it doesn't make sense, it's not true. Now, when you came back a month later, what else did you do? Didn't clean up a mess. Just a second. Didn't clean up a mess.
Yes, I cleaned up the mess.
You cleaned up what mess?
My mess. He
your
doesn't
mess.
clean up his mess.
Well, you didn't. That's what you told you.
No, I have other reviews of other people on the internet that posted that.
I'm asking you a question. You didn't clean up his mess.
I didn't clean up his mess. I misunderstood you.
Okay, well, that's what I said.
sorry.
You didn't clean up his mess.
No, I cleaned up his mess.
And didn't write a review.
Well, I didn't know about you.
I'm telling you, you can say it until the cows come home. I don't
true, Your
believe
Honor.
you. I don't believe you. And I don't believe that the first year that you found out to write a review is when you and Mr. Burnley started a relationship. I just don't believe it.
No.
And I think it's mean-spirited. You have to know, Miss Booth, I think it's mean-spirited.
But we were seeing each other in 2014.
You were seeing each other in 2014.
Yes.
You have a company, sir?
Yes, I
Do you have a company?
Yes.
Are you licensed?
Yes.
What's the name of your company?
DMB Electric Inc.
Just would you take a look at that, Sarah?
It'll be under DMB Electric Services Inc.
And in what year was your company formed?
This one, 2013.
He had a prior
I had a prior one.
2013.
Yes, Your Honor.
Was that before or after you did her job with him? Before
The
or
license-
after?
I had the license before.
No, the company. I said, was the
Yes,
company
the company
formed?
was established.
Careful, because she's a whiz with the computer.
No, that's good.
Was your company formed before?
Yes, Your Honor.
Before you did the job with him?
Yes.
Okay, in what month in 2013?
I don't know.
Are you
what date.
guessing?
Yeah, I'm going
Are
to
you
guess
guessing?
January. Yes.
Was it before or after you did the job with the plaintiff? If you don't know the answer, say, I don't remember.
I don't remember.
Okay, now.
The business was incorporated March 20th of 2013.
Does it have any reviews?
Only 4 from the past 2 years on Yelp, all positive.
By the way, did you ever write a review for him? Did you ever write a review for Mr. Burnley's company? Is not an answer. Did you ever write a review for Mr. Burnley's company? Stop shaking your head, Mr. Burnley. Did you ever write a review for Mr. Burnley's company?
No.
Okay. I don't know what it is that you didn't understand. Sir, you didn't say much. You don't have to say much. I got what went on here, and I think it was mean-spirited, and you're suing for $10,000.
Yes, Your
I
Honor.
think that their reviews and the abuse of the critique of your business warrants the award of $10,000. You have a counterclaim. Which one of you has a counterclaim?
I do.
Yeah, I'm going to tell you something. Your counterclaim's dismissed. I think that you were a co-conspirator in her writing these reviews.
Was not.
Counterclaim is dismissed. Judgment for the plaintiff in the amount of $10,000. We're finished here. Thank you very much.
Your Honor.
This court
We're
is
done.
adjourned.
Outside the courtroom, John, then Dwayne.
During the COVID shutdown, when nobody had any work in a small community of 5,500 people, that's what they chose to do.
Hey, I'm glad it's behind me, man. That's all I can say.
He was just getting his license, and I helped him begin his business, and this is how he serves me.
Sarah and Judy.
I agree with the judgment, but why $10,000? That seemed a little high for me.
You can permanently hurt somebody's business, their livelihood, if you write a negative review. Because people more and more rely on the internet when they seek a service, rely on somebody else to say, I've had a good experience or I've had a bad experience. I believe, based upon the timeline that we heard, that the defendants wrote these reviews for a reason other than bad electrical work. Because if there was bad electrical work, that would have shown itself between 2013 and 2018 when her fiance redid the whole system.
Or it wouldn't have passed the inspection.
Or it wouldn't have passed the inspection. So that, to me, is malicious. I think you have to get a real wake-up call. And to me, $500 doesn't do it. It's malicious, and I don't think he has to show any real damages other than the reputation of his business has been sullied by someone for malicious reasons having nothing to do with work that was performed 9 years before. And I'm perfectly comfortable with that judgment.
Title: Judy Justice.
Have you been cheated? Go to judyjustice.tv.